Good morning, everyone. It's my pleasure to welcome you back to JAI Week 2024. This is day 2, and today we have a very exciting presentation on anti-money laundering. All protocols observed from yesterday, and it's my esteemed pleasure to welcome our 2 presenters this morning. Our first presenter is Justice Carla Brown-Antoine, and our second presenter will be Justice Mohammed. Both presenters are Justices of Appeal from Trinidad and Tobago. Their bios will be shared with you in the programs which will be circulated in the chat and which has been circulated before. Okay, so without further ado, I'd like to hand this over to Justice Carla Brown-Antoine. Good morning, Justice Brown-Antoine.
Yes. Good morning, Antonio, and good morning to everyone, all the presenters. I want to acknowledge, I think the Honorable the Chief Justice is present, so I acknowledge the presence of the Honorable the Chief Justice and all the other justices, judicial officers, and other participants. Good morning. Thank you for having us, Justice Mohammed and myself, at your JAI Week. And I recognize also some of my former colleagues from Trinidad and Tobago, Justice Silochan and Justice Tiloxi. All right, so my presentation is going to be on anti-money laundering. I will start sharing my screen with the PowerPoint presentation. Not seeing, somehow I'm not seeing it myself. So I share again. Here it is. I'll try to fill the whole screen.
No, we can't see it, Judge.
Yes, I know. I don't know why it disappears when I try to get it to fill the whole screen. All right, so maybe I'm trying to put it on slideshow.
Yes.
And when I do that, it goes blank, but I'm going to try once again. Right, there it is. Yes, everyone is seeing?
Yes, excellent, Judge. Thank you.
Yes, all right. Thank you, everyone. And so I may take a few brief questions during the presentation, but you feel free at the end of the presentation. Once we have time, I will take questions. And if we don't, we can save the questions for this afternoon. So as you can see, my presentation is entitled Anti-Money Laundering Law in the Turks and Caicos Islands. So these are the objectives that I hope will be achieved by the end of this presentation. That you will gain a greater understanding of anti-money laundering law in the Turks and Caicos Islands, that you will be able to identify money laundering offenses and how they are proved, and that you will have greater confidence in adjudicating on money laundering cases that come before you. So those are the objectives. Now in the 1 hour that I have, we are only able to do a very brief overview of the law. So hopefully we would be able to capture the more important aspects of the law. So what is money laundering? Money laundering is the practice of disguising the origins of illegally obtained money. The aim of penalizing money laundering is to penalize the criminal offenders, for being in possession of or dealing with, let's see, put it that loosely, dealing with the proceeds of crime. That's the aim of money laundering, to penalize offenders dealing with the proceeds of crime, whoever they may be, whether they are the persons who committed the crime or whether they are the persons into whose possession the proceeds have come. That's the purpose of money laundering, in order to discourage persons from engaging in crime or associating themselves with persons who engage in crime. That is the purpose of money laundering law. Now, it's called money laundering, but we know not only money is laundered, all types of property can be laundered. So it is a process by which the proceeds of crime are made to appear legitimate. So the purpose of the criminals who launder money and other property is so that they can hide and conceal the proceeds of their crimes. And of course, the criminal property can be generated by any number of criminal acts, including drug dealing, corruption, accounting, fraud, other types of fraud and tax evasion. So that money laundering targets, anti-money laundering laws target all types of crimes. It's not limited to property generated from any specific type of crime. And this is what the criminals do. They engage in these offenses and then try to conceal the proceeds of their criminal acts. And the methods by which money may be laundered are varied and can range in sophistication from simple to complex. So there are stages of money laundering have been identified. There's placement, layering, and integration. Now, all money laundering may not take place in this way, but generally speaking, they've identified that money laundering can occur in this way. That is, with placement, the money is accumulated from illegal, or the criminal property is accumulated from illegal activities. It is then placed into the financial system. That's placement. Layering is where the money is transferred and moved around in order to hide the origin of the fund. And then integration occurs where the money enters the financial system or enters the economy, as it were, in a different way, in a different form, and almost, as I say, as clean money now, or appears to be clean, and is available for the perpetrator or his associates to dispose of or to utilize in whatever way they see fit. So once again, placement is the first stage in the washing cycle. It's called washing and money laundering. It's laundering money, turning dirty money into clean money then. And this is achieved by investing criminal money into the legal financial system, by opening up a bank account, for example, in the name of unknown individuals, or even in the name of the perpetrators, organizations, and depositing the money into that account. It may also involve something called smurfing, which is where the launderers make use of numerous deposits of money that are small enough to avoid suspicious. Because you know now, with the detection, with the methods that are put in place for detection, such as source of funds, declarations, and all of these things, they realize that money over a certain value would attract attention. And so smurfing is a technique of breaking it up into smaller amounts and depositing it in small amounts, maybe even into multiple accounts. So these are examples of placement, repaying of loans, gambling, moving currency, illegally or by virtue of monetary instruments across the border. So physically moving the currency or moving it through monetary instruments, using currency exchanges, purchasing foreign currency with illegal funds through currency exchanges, and blending funds, using a legitimate cash-focused business to mingle dirty funds with the day's legitimate sales receipts. So those are examples of placement. Then we have layering. And the purpose of layering is to disassociate the illegal monies from the source of the crime by purposely creating a complex web of financial transactions aimed at concealing any ordered trade, as well as the source and ownership of funds. So layering is creating a web of financial transactions, as you say, breaking up the money, sending it into various accounts, doing different things with it, creating an audit trail that can't be, that is complex. And by reason of the frequency, the volume, complexity, it may resemble a legitimate financial transaction. Some examples of layering: moving funds electronically from one account to another, from one country to another, dividing them into various investments placed in financial products or overseas, and constantly moving investments around to elude detection. It is thought by creating all these different transactions, eventually you will not be able to trace the source of the money at the end of the deal. Now we come to integration. This is the final stage in the process. It is at this stage that the money is integrated into the legitimate economic and financial system and is assimilated with all other assets in the system. So having moved it around, carried it, split it up, sent it here and there, you finally get integration of what they think is clean money into the economy. And because the money now appears to have been legally earned. And the profits that are made from investments and investing in businesses, converting it into assets. These profits may be reinvested in a criminal enterprise, invested in other assets, or used to support an extravagant lifestyle. So those are the three processes identified in or three stages of money laundering. And examples of integration, which I've just said, about purchasing property, artwork, jewelry, high-end vehicles, yachts and boats, and so on. And of course, investments in the stock market, investments in other types of bonds and securities, and so on. So the law in the Turks and Caicos. The law in the anti-money laundering law in the Turks and Caicos is mainly found in the Proceeds of Crime Ordinance, Chapter 315, which we will call POCO. In other islands, it's called POCA, but since it's still an ordinance in this jurisdiction, we call it POCO for short. The money laundering aspect of the law is found particularly in Part 4 of the ordinance, from sections 115 to 131. Justice Mohammed will deal with other aspects of the act that deal with civil recovery. And the money laundering offenses are created by sections 124 to 129. There are also regulations and the code made under the act, and they can be found in the same place in the volume as the Anti-Money Laundering and Prevention of Terrorist Financing Regulations 2010 and the Code 2011 Code. Now, I can say here that generally speaking, across the Caribbean, anti-money laundering laws are generally the same. They have many similarities in the laws across the Caribbean. They're not identical for the most part, but they're generally very similar. With respect to the Turks and Caicos laws, that is almost identical to the laws in Bermuda and Jamaica. So some laws are quite similar, and your law is quite similar to the laws in Bermuda and Jamaica. There are also laws, of course, for the Caribbean. I've looked at laws in St. Vincent and the Grenadines, in Grenada, of course, in Trinidad and Tobago. There are some similarities and a few different. So that means that you can find authorities, case law, and so on can be utilized across the Caribbean because there are many, many aspects of the law that we have in common. So what are the money laundering risks that are in this jurisdiction? Now, I've looked at your national risk assessment. The first one was conducted in August. Well, it was conducted over a period of time. The report was published in August of 2017. So I highly recommend, if you have not read the National Risk Assessment, I highly recommend that you take a look at it. It identifies the money laundering risks that are present in the Turks and Caicos Islands, and it was conducted by the Anti-Money Laundering Committee. This committee is set up, I should have put in the section of the act, but it's set up under the act, the Anti-Money Laundering Committee, headed by the Attorney General, and including of high office holders across the legal and the law enforcement agencies. And they have certain tasks which are identified in that. And one of their tasks was to do a national risk assessment, which they did. And they assessed the risk of money laundering occurring in the Turks and Caicos Islands as medium to high. A second NRA was recently launched in July of 2024. And they found that the risks for money laundering were high in relation to, medium high in relation to the financial sector. And because of the layout, because of the nature of how the islands are made up of an archipelago islands, which can be easily accessed by boats and so on, that they found that the Turks and Caicos Islands were at risk for being in fact, a transshipment point for drugs and other illegal trades across, in the islands. It's a transshipment point. So those are really the two areas that present the risk for money laundering in the Turks and Caicos Islands. Now, they've launched a second NRA in July. So I guess you wait, and that report should be out as soon as that assessment is completed. As I said, these are the risks that were identified in the report. It said that the Turks and Caicos Islands has a number of characteristics that indicate that the threat of money laundering from international sources is real. The most common characteristics being an international financial services center and high-end Caribbean residential property market, attractive to those wishing to acquire desirable assets of value. And the domestic threat is of internally generated money laundering is mainly based on low-level drug price. So these are the two main risks that were identified, money laundering risks identified in that report. And I've looked to see whether there were any prosecutions for money laundering in the Turks and Caicos. And you can correct me if I'm wrong here. What I was able to find is that there were several persons prosecuted for money laundering following a commission of inquiry into allegations of corruption in 2009. And several of those matters have come to trial, and I've only been able to find one attorney convicted of money laundering, and of money laundering offense, that is concealing the proceeds of criminal conduct. If there have been any others, you can let me know at the end. So what are the money laundering offenses that have been created in the Proceeds of Crime Ordinance? There are three principal offenses. The first being concealing, disguising, converting, transferring, or removing criminal property. The second being entering into or becoming concerned in an arrangement, knowing or suspecting that it facilitates, by whatever means, the acquisition, retention, use, or control of criminal property by or on behalf of another person, and acquiring, using, or possessing criminal property. So right away, you see that money laundering offenses target not only the perpetrators of what we call the predicate criminal offense, the offense which generated the criminal property. It targets everyone who deals with the criminal property, whether they've received it, whether they've acquired it, whether they're in possession of it, whether they make arrangements to hide it, to conceal it, to put it out of the reach, to put it under the control or available for the use of someone else. So the first offense is created by Section 124 of POCO. And this is Section 124 states that, subject to subsection 2, a person is guilty of an offense if he conceals criminal property, disguises criminal property, converts criminal property, transfers criminal property, or removes criminal property from the island. So we see that dealing with criminal property is an offense in these ways. So what we need to understand is what is criminal property. That's an essential element of the offense that is created by Section 124, and in fact, all the offenses. So first we looked at what does concealing and disguising mean. And it's in an inclusive definition. Concealing or disguising criminal property includes concealing or disguising its nature, its source, its location, its disposition, movement, or ownership, or any rights with respect to it. So if you do any of these things, then that amounts to an offense. So as I said, it's essential to the offense that you are dealing with criminal property. So of course, the Act defines criminal property in Section 122, the ordinance. And the criminal property is property which constitutes a person's benefit from criminal conduct or represents such a benefit in whole or part, and whether directly or indirectly. So now criminal conduct becomes important because criminal property is the benefit of criminal conduct. But there's also a mens rea aspect to the definition of criminal property. And the alleged offender, the person who deals with the criminal property, must know or suspect it constitutes or represents such a benefit. So now we have to look at criminal conduct. In relation to criminal conduct, certain matters are immaterial. For the purposes of the section, it is immaterial who carried out the conduct, who benefited from it, or whether the criminal conduct occurred before or after the 8th of October, 2007. That is the date the ordinance came into force. So it doesn't matter in relation to the criminal conduct who carried out the conduct, who benefited from it, or when the conduct occurred. Now, what is a benefit is dealt with in section 5.4 and section 122.3. And it says that the person benefits from criminal conduct if he obtains property as a result of or in connection with the conduct, and his benefit is the value of the property so obtained. So the benefit is property obtained from criminal conduct or in connection with criminal conduct. That's what a benefit is. Now, what is criminal conduct? And as we can see from section 5.1, criminal conduct is any offense. It may be a summary offense, it may be an indictable offense, any offense, which is any conduct which is an offense in Turks and Caicos Islands. So in section 5.1, it defines criminal conduct as conduct which constitutes an offense in the islands or would constitute an offense in the islands if it had occurred in the islands. So any offense committed amounts to criminal conduct, and any benefit from that conduct constitutes criminal property. So let's look at the offense created under section 124, concealing and disguising and so on. These are the elements. This is what the prosecution must prove. The act of concealing or disguising and the other ways in which you can commit the offense. In relation to property, which we just defined, criminal property, that is property derived directly or indirectly from criminal conduct. And there is mens rea. That is, the defendant knew or suspected that the property was derived directly or indirectly from conduct. And we know that in the mental element of an offense is normally proved by inference from certain evidence. So these are the elements of a section 124 offense. Now, one of the challenges of establishing money laundering offenses, such as a 124 offense, is proving that the property represents the proceeds of crime. That may be one of the most difficult aspects of a money laundering prosecution. Now, there was a view when these offenses were initially created, there was a view that the prosecution had to prove the actual offense that was committed that resulted in the criminal property. So you had to prove a link between the criminal property and the commission of an actual offense. And you had to identify what that offense was, and you had to identify who committed that offense in order to succeed in a money laundering prosecution. That was a view that was held. And that view was put to rest by the case of Anwar, which was followed later on by in other offenses, in other matters, in other Caribbean matters that were tried in the Caribbean. So Anwar, so as I said, the UK Proceeds of Crime 2002, Proceeds of Crime Act 2002 is also quite similar to the law in the Turks and Caicos. It's also similar to the law in Bermuda and Jamaica and across the Caribbean. And this case, Anwar, is a case from the Court of Appeal of the UK, where it was said by Lord Justice Latham that there are two ways in which the Crown can prove the property derives from crime. The first way is by showing that it derives from conduct of a specific kind or kinds, and that conduct of that kind or kinds is unlawful. So that is the first thing, by showing that the property was obtained from certain specific kinds of conduct. Or the second way, by evidence of the circumstances in which the property is handled, which are such as to give rise to the irresistible inference that it can only be derived from crime. So right away, these decisions, the decision in ANWR and those that have adopted it and followed it, put to rest that the prosecution has to prove a specific crime. They can prove by the way that the property is handled that there is an irresistible inference that it has been derived from a crime. So as I said, ANWR was followed. Let me just explain ANWR. So essentially, ANWR states that prosecutors are not required to prove that the property in question is the benefit of a particular or a specific act of criminal conduct, because such an interpretation would restrict the operation of the legislation. The prosecution need, as a minimum, to produce sufficient circumstantial evidence or other evidence from which an irresistible inference can be drawn to the required criminal standard that the property in question has a criminal origin. In other words, there could be no reason for the circumstances for the criminal property, for the dealings with the criminal property, for the way in which the criminal property was handled, other than a criminal one. Other than a recognition by the person dealing that this is criminal property and it needs to be concealed, disguised, moved around, laundered, and made clean. Now, ANWR was followed in a case called Jellizo. Jellizo is a case from the St. Vincent and the Grenadines, where you will see why the issue arose in this case. So in this case, the St. Vincent and Grenadines Coast Guard found a large sum of money hidden on a yacht docked off the coast of a Grenadine island. Financial investigations and direct evidence revealed that the yacht was sold. It was sold to the appellant, Jellizo. The appellant was accordingly convicted by the chief magistrate of 2 counts of money laundering. He was convicted of concealing the proceeds of criminal conduct contrary to their act and transferring the proceeds into St. Vincent and the Grenadines. Now, he appealed against his conviction to the Court of Appeal of the Eastern Caribbean Supreme Court, and the main thrust of his appeal was that the chief magistrate had erred in holding that the prosecution did not have to prove that the money found on the yacht came from a precise source or crime or the predicate offense. So the chief magistrate had found that the prosecution didn't have to prove that they simply found money on a yacht. Prosecution didn't have to prove that that money came from a precise source or crime. The Court of Appeal upheld the conviction and found that the chief magistrate had correctly held that once the prosecution had produced cogent circumstantial evidence from which the proper inferences could be drawn to the required criminal standard that the property in question was the proceeds of crime, it would suffice to secure a conviction. There was no need to show or particularize the offense or offenses which generated the proceeds of crime, or the provenance offense, or sometimes it's called the predicate offense. If the legislator had required the prosecution to establish a particular offense, it would have clearly so stated, and there was no need to read such words into Section 41(1) of the Act. Accordingly, in money laundering offenses, there was no need to prove the provenance offense. Proof of a particular predicate crime was not an essential element of the offense, and so that ground of appeal failed. So that was Jellizo, which followed Anwar. And I wish, and again, as I said, the Jamaican law is quite close to law in the Turks and Caicos. So Jamaican cases are, authorities are relevant. And I want to direct you to the case of Re-Assets Recovery Agency, Jamaica, decided in the Privy Council in 2015. Now this case reaffirmed the principles in Anwar. And this was an application for a customer information order. And under POCO, you do have, you have the ability to apply for customer information order under sections 140 to 144. Now, in this particular case, the Assets Recovery Agency of Jamaica appealed to the Privy Council from the decision of the Court of Appeal of Jamaica, dismissing its appeal from the decision of the judge, refusing its ex parte application for a customer information order pursuant to their sections of their act. The Privy Council considered in particular whether before a customer information order could be made in aid of money laundering investigations, it was necessary that there should have been a conviction of somebody for the antecedent or predicate offense, which had caused the property to be criminal property. Now, in fact, the Court of Appeal had actually held that the prosecution had to prove a criminal conviction before they could apply for a customer information order. So not only did the prosecution have to prove, according to the Court of Appeal, that the offense had been committed, they had to prove that someone was convicted of the offense. And we see that Anwar had decided, apparently Anwar was not cited to the Court of Appeal in Jamaica, but Anwar, the Privy Council found that, debunked that submission. And they found that there can be no doubt that this means that before a substantive offense of money laundering can be committed, there must have been an antecedent or predicate offense. So the Privy Council found that the law means that because of the definition of criminal property, it's derived from criminal conduct, there must be a substantive offense. And you have to prove that that an offense was committed or criminal conduct was committed. So before there can be money laundering, there must have been an antecedent or predicate offense committed by someone, which generated the criminal property concern. So for a prosecution for a substantive money laundering offense to succeed, the Crown must prove that such an antecedent offense was committed by somebody. Exactly which antecedent offense is or maybe is or to be proved may be uncertain. But the inference that some antecedent offense or offenses were committed may be sufficiently irresistible to amount to proof to the criminal standard. So again, they're repeating the irresistible inference that an offense was committed. So they were not saying that you must prove somebody, and a named person, an identifiable person committed the antecedent offense, but that there was an irresistible inference that such an offense was committed to the criminal standard, of course. In such circumstances, the board held that proof of a particular predicate crime is not necessary in order to prove a substantive charge of money laundering. So you can look at asset. I think you've gotten the point. That was proven by several authorities. Now, the section 125 offense. A person commits an offense if he enters into or becomes concerned in an arrangement which he knows or suspects facilitates by whatever means the acquisition, retention, use or control of criminal property by or on behalf of another person. So this is the one, this is called the arrangement, entering into arrangements to facilitate someone else acquiring, retaining, using criminal property. What does this offense cover? This offense includes a wide range of activity, including those who launder on behalf of others, usually at the layering and integration stages, which we looked at earlier. So this is meant to cover those who are laundering money on behalf of others. It can catch individuals who work in financial or credit institutions, accountants, lawyers, or other professionals who facilitate money laundering by or on behalf of others in the course of their work. Now, the requirements under section 125. It requires a definite arrangement, which D, the defendant, knows or suspects, facilitates, and not just will or may facilitate, the acquisition of criminal property by or on behalf of another person, who must already be identified or at least identifiable. And you can look at the case of Deere in relation to that aspect. And in Squirrel Limited and National Westminster Bank, it was said that the purpose of 328(1), which is similar to section 125, is not to turn innocent third parties into criminals. It is to put them under pressure to provide information to the relevant authorities to enable the latter to obtain information about possible criminal activity and to increase their prospects of being able to freeze the proceeds of crime. Now, because one might get a little apprehensive when you read that a person in their going about their normal duties as a lawyer, as an accountant, can end up being charged or found to have facilitated someone else acquiring criminal property. But if you look at section 125, you will see that there are exceptions. There are ways in which persons, for example, like lawyers, certain matters are privileged, matters which come to their attention to professional privilege are exempt from disclosure and exempt from being investigated, as it were. So the Act does have safeguards for persons who are acting lawfully in their professions as a result of their professions. The elements of the section 125 offense, the prosecution has to prove that the defendant enters into or becomes concerned in an arrangement which he knows or suspects facilitates by whatever means the acquisition, retention, use, or control of criminal property by or on behalf of another person. And now we come to the third offense, main offense, section 126, acquisition, possession, or use of criminal property. So a person commits an offense if he acquires criminal property, uses criminal property, or has possession of criminal property. Now, it is a defense to a charge of committing an offense under this section that the person charged acquired or used the property or had possession of it for adequate consideration, and he did not know or suspect that the property was criminal property. So there's a provision, as I say, there is protection for persons who deal with property for consideration, not knowing that it is criminal property. And once again, the elements, the prosecution has to prove acquisition, use, or possession of criminal property. And the mental element, that the defendant had the necessary knowledge or suspicion that the property represented a benefit from criminal conduct. That's what criminal property is, a benefit from criminal conduct. And as I said, this section doesn't distinguish between criminal property that represents the benefit of some other person's crime and that which represents the benefit of a crime which the particular person dealing with it has committed. So as I said, once you are dealing with criminal property or property which can be shown to be somebody's benefit from a criminal conduct, it will, you will have committed, of course, with the mental element, you will have committed the offense. So as I said, as an example, a thief who uses or retains possession of property that has just been stolen, this being criminal property as defined, must therefore be guilty of an offense under 126(1)(b) or C. There is mens rea, there's a mental element, as I said. Dishonesty is not required, nor need he know or believe that the property in question is criminal property. Mere suspicion will suffice. So if he knows or suspects, if he knows or suspects that the property is someone's benefit from criminal conduct. Let's look at a case study of an actual money laundering offense that occurred in Grenada. And it occurred in this way, by way of ATM fraud. So this is an actual offense, person convicted in Grenada. In late October 2016, an East Asian national arrived in Grenada from a Caribbean country. And on November 7, 2016, information received led police in the FIU to carry out a search of his hotel room. That search revealed a large quantity of US and EC cash, one laptop computer, 16 dummy ATM cards, one router, 2 flash drives, 1 external drive, 1 ATM card reader, and 2 USB cables. So this is how money laundering can occur. The subject was interviewed under caution, and he confessed to cloning ATM card holders' information onto dummy cards in his possession and using those cloned cards to make cash withdrawals from persons' accounts through ATMs in Grenada. So basically what he was doing was stealing money from people's bank accounts using these cloned ATM cards. It turned out that the subject was in Grenada and receiving information from an accomplice in East Asia who was stealing information from persons in that region who used ATMs. That information was cloned onto the dummy card and used to make withdrawals at ATMs. He was subsequently charged with fraud and money laundering offenses. He pleaded guilty and was fined a sum of US 7,000 on summary conviction. He paid the fine but was deported by an order of the court. So this is how money laundering, this is one of the ways in which money laundering can occur. Through ATM fraud. So that brings me to the end of my short presentation. And so I ask if there are any questions. I am good answer at this point. Anything that arose, anything that you need clarification on in the presentation, or anything that I can assist you with further in relation to the proceeds of crime audits. Thank you.
Thank you very much for that presentation, Judge. So if there are any questions, feel free to ask it. or feel free to place the questions in the chat.
All right, there seem to be no questions. Presentation did go. All right.
There is one question.
There is one. With respect to the principle derived from Squirrel Limited, would it be fair to say?
The question is, with respect to the principle derived from the Squirrel Limited case, would it be fair to say that an innocent third party has a duty to report to the relevant authorities as soon as the suspicion arises?
Yes, in fact, there are provisions in the Act for persons to make disclosures, it's called, approved disclosures. So in most of those sections, you will see, so for example, in section 124, if I could pull up the Act itself, you will see that there, before you do anything, if you make a relevant approved disclosure, you aren't liable for the offense. So if we look at, I'm just going to pull up the actual Act to show you an example of that. So let me just pull it up. It's taking a while. So under section 124, for example, 124.2 says a person is not guilty of an offense under subsection 1 if he makes an authorized disclosure, and if the disclosure is made before he does the act specified in subsection 1, he has the appropriate consent. So the Act provides that you can disclose matters to the Financial Intelligence Agency. If you're working in a bank, there's somebody called a money laundering reporting officer. If you come into possession of information where you suspect that there is some kind of money laundering going on, this person is dealing with criminal, what you're dealing with is criminal property, you can make a disclosure to the Financial Intelligence Agency, and they are supposed to respond to you and say, you can go ahead and do, or don't do it, go ahead and do it. And if they give you consent to deal with the property, then you will not be guilty of an offense under that. And each one of the sections has that prevention, that section about making a disclosure. But the disclosure you can't just make the disclosure and then that's the end of it. You must get a response, a consent. If you are still to continue to deal with the property, you must get consent from the relevant agency. And the relevant agency is usually the Financial Intelligence Agency. So I hope that answers your question, that disclosures are encouraged under the Act, and that persons who do, before dealing, if they are unsure whether they should be dealing with criminal property, they suspect what they are dealing with is criminal property, they make a relevant disclosure to the Financial Intelligence Agency. And you will see that in relation to all three of the offenses. Yes, all right, so thank you, Sasha, for that question. I'm happy that I was able to answer it. All right, so you have another question? I think Sasha had another question.
Yes, I think she's typing it.
Oh, okay.
Yeah. I'll just remind everyone as well that there will be time for questions this afternoon at the close of both presentations. So we have two additional questions.
Yes, sure.
From Mr. Missick, attorney at law. For the purposes of the ordinance, how is suspicion determined?
How is suspicion? You mean, when they say you know or suspect that something is criminal property, the person must know or suspect? Is that what you mean?
He's saying suspicious activity.
Suspicious activity. How is suspicious activity determined? All right, so Mr. Missick, unmute your mic and let me hear you. And clarify what exactly you want to find out about. Yes, Mr. Missick?
Well, yeah.
Yes, go ahead.
The act requires knowing a suspect, and my question is, how does one in a professional setting who has dealt with clients on a regular basis suddenly suspects that something is awry?
Well, first of all, as an attorney, you ask a lot of questions. So the client comes to you because knowing that if the client has come to you for legal advice, that conversation between you and the client is privileged. And even the act protects communication that is under privilege, covered under legal professional privilege. So you can feel free to ask the client who has come to you for advice questions. And by asking those questions, you will, because each case is different. As you've seen, money laundering can be committed in so many different ways. It's such a wide offense. It can be committed in so many different ways. But for example, a client may come to you asking you to put property in the name of his son, to transfer property to his children, or to a cousin, or to somebody who is not related to, for no consideration. That may raise a red flag. So that there are so many ways. So what I would suggest is asking a lot of questions, knowing and understanding that the answers you get may be covered or are more than likely covered, because they've come to you to utilize a legal service. They want you to facilitate transfer of property. They've come for you for legal advice. That communication is legally privileged. So that by asking questions, what is the consideration? Why is there no consideration for the transfer of the property? Why are you putting it in the name of this person who is not related to you, as opposed to somebody who's related to you? I think asking questions, you can gain suspicion, and then probably you can get advice from the Financial Intelligence Agency about whether they think that those circumstances may suggest that the criminal, you can even ask your client, I would imagine, where did you get $1 million from? They may or may not have an answer for you.
I think that ties into Ms. Ferguson's second question, which is what is the best way to balance the principle of client-attorney privilege and the duty to report any suspicious activity?
Well, you know, as I say, once the client comes to you, I don't know there's a duty to report, though, especially if it's a privilege matter. I don't know that there's a duty to report a privilege, because you may just suspect, you may not have evidence that it is in fact criminal property. You may suspect that it is. But I think the fundamental, because the Act recognizes the fundamental principle would be legal professional privilege. So that I don't know, I don't think I've seen a duty to report, anything called a duty to report, unless you are witness to the crime that resulted in the criminal property. What you may have is a suspicion that it is criminal property. And then you decide, you decide whether you decide whether you deal with it or not. And be mindful, as I said, of the sections that deal with making a disclosure. Yes? Be mindful of the sections that, so if you suspect that it is criminal property, you have regard to the sections that deal with making a disclosure, and you decide whether you should make a disclosure under those sections. That's the assistance that I can give you, generally.
Okay, thank you so much. Thank you so much, Judge.
Yes, you're welcome.
So I think that'll be the end of the questions for this first half of the presentation.
Yes. All right, so I turn over to Justice Mohammed.
Yes, so I'd like to welcome again Justice Mohammed, who will continue informing us about anti-money laundering.
Thank you very much. First of all, I want to begin by reiterating what my sister, Justice Brown-Antoine, said in terms of the gratitude expressed to the Honorable Chief Justice of the Turks and Caicos. And also, I wish to add the President of the Court of Appeal, President Alice York-Suhan, the members of the JEI, for inviting us to present on this very important topic for the Turks and Caicos against the background of what I consider to be compendious legislation, your Proceeds of Crime Ordinance, very thorough legislation. So the topic of my presentation is on civil asset detention and forfeiture in your islands. And I just wanted, by way of delineating the extent, or the limits rather, of my presentation, to indicate to you what I am not presenting on. I will not be presenting on confiscation orders, which are contained in Section 13 of your Proceeds of Crime Ordinance, which will be referred to and has been referred to by my sister as POCO, the acronym. That again is, I know for you, a very substantial area, but my focus will be purely on civil asset forfeiture, so that my focus would be on part 3 of POCO, the sections that pertain to civil recovery, and not all the sections of that, because most of you, if not all of you, would be acutely aware of the fact that some of these sections under part 3 are very involved. And during the course of 1 hour, it would be impossible to go into all the various aspects. So just by way of an overview, part 3 of POCO, which deals with civil recovery, has in its preliminary section under section 60, the meaning of unlawful conduct. Under section 61, the meaning of property obtained through unlawful conduct. And it goes through various subheads: recoverable property and associated property, recovery orders and property refreezing orders, interim freezing orders, vesting and realization of recoverable property. So the time of 1 hour simply does not commit us to go into the iterations of all of those areas. So I will endeavor to focus on some essentials, and endeavor to ensure at the end of my presentation that you are able to understand what cash means under POCO, that you appreciate who can seize cash under POCO, that you understand the conditions precedented for the search, seizure, detention, and forfeiture of cash under POCO, that you understand the applications for further detention orders, and that we engage in some level of dialogue about the potential need for further legislation concerning civil asset forfeiture and recovery. And in this regard, I'm going to commend to you a unexplained wealth order scheme such as exists in several jurisdictions, including the United Kingdom, fairly recently in Trinidad and Tobago, and also in Australia. And that will come at the very end of my presentation. So first of all, what is cash under POCO? Under section 2, subsection 1, cash is defined as including notes and coins in any currency, postal orders, checks of any kind, including traveler's checks, banker's drafts, bearer's bonds and bearer's shares, and any kind of prescribed monetary instrument. A conjoint reading of section 105, subsection 1, and section 2.1 of POCO reveals that a police or customs officer in your jurisdiction is entitled to seize, and I'm just using this by way of one example, a check, where a check, for example, is under suspicion. So using the check as an example, where only, let us say, part of the check in question is under suspicion and has been seized and detained for a further period. Under section 108, subsection 2 of POCO, this allows an officer to pay that check into an interest-bearing account and release the part of the cash, in this case, the check, which falls within the partial inclusive definition to which the suspicion does not relate. You would also note that cash can be any kind of prescribed monetary instrument. With several new forms of currency abounding, it is useful to interrogate what new forms of currency can and cannot fall within the definition of POCO. And of course, what comes immediately to mind would be Bitcoin. And perhaps I would venture to ask, any preliminary views on this? Because you haven't seen the ensuing slides, so you would know what the answer to the question is in the English law. If you had to determine the question of whether e-currencies such as POCO, such as Bitcoin, fell within the definition of cash, what would be your legal response to that? Would anyone like to take a go at that? Or would you leave it for me? I suspect you're leaving it for me. All right. There is a decision in AA against Persons Unknown 2020 for weekly law reports at page 35. The facts are very brief. A company had had its computer systems encrypted by the first and second defendant hackers. The company was insured against cybercrime attacks with the claimant insurer, which agreed to pay a ransom in return for the relevant decryption software. The claimant's agent transferred bitcoins to an address that was linked to an exchange operated by the third and fourth defendants. Since cryptocurrencies were neither choses in possession nor choses in action, the question arose in this matter whether the bitcoins held in the account with the third and fourth defendants were property. So how was this question answered? The conclusion was expressed that it was a crypto, that although a crypto asset might not be a thing in action on a narrow interpretation or definition of that term, that did not mean that it could not be treated as property. Essentially, and for that reason, the judge said that crypto assets such as Bitcoin are property because they meet the 4 criteria set out in Lord Wilberforce's classic definition of property. And let's remind ourselves here of what are those 4 criteria. They are: 1, that it is definable; secondly, that it is identifiable by third parties; thirdly, that it is capable in their nature of assumption by third parties; and fourthly, that it has some degree of permanence. So it was considered that crypto assets complied or comported with the 4 criteria of property set out by Lord Wilberforce in his classic definition in National Provincial Bank against Ainsworth 1965 appeal cases. There is also the decision, a very recent one as well, in DPP against Breedis 2021, England and Wales High Court, and a decision of the Administrative Court, which dealt with an application for a property freezing order under Section 25A of the United Kingdom Proceeds of Crime Act of 2002. And in that case, the judge noted at paragraph 10, I am satisfied that cryptocurrency as crypto assets fall within the definition of property, and the section is given. In the interest of time, I will skip it, especially when viewed in light of the purpose of these statutory powers. These words are noteworthy. It would be a serious lacuna if crypto assets fell outside the reach of this statutory scheme. So the answer is a resounding yes. Crypto assets are capable, because they comport with the definition of property, they are capable of amounting to cash as defined in POCU. They are subsumed within that definition. So we proceed now to look at the various facets of dealing with a property under POCU. And we are going to look at searches, detention, continued detention, and eventually forfeiture. And let us try to situate why it is necessary to interrogate this to begin with. It is because the commission of criminal offenses is usually driven by a desire for monetary gain. And it is said, in theory at least, that if one hits the criminal in the pocket, where the pain is felt most acutely perhaps, rather than dealing with the matter in a myopic way, one takes the profit motive, or one hits the profit motive, and that serves or can serve as a deterrent. So that is why there has been focus in the last 30 years, an evolving focus in the last 25 years, 20 years, on civil asset forfeiture and recovery. Returning now, starting with searches under POCU and your search regime. Police officers who are lawfully on any premises and who have reasonable grounds for suspecting that there is recoverable cash on the premises may search for cash there. That is under Section 105. Section 105 provides that a police officer who is lawfully on any premises and who has reasonable grounds for suspecting that there is recoverable cash on the premises may search for the cash there. And we will come to how recoverable cash and recoverable property is defined in a bit, because all of these terms are interwoven and defined by your POCU. Subsection 2 of 105 provides that if a police officer has reasonable grounds for suspecting that a person, the suspect, is carrying reasonable cash, he may A, so far as he thinks it necessary or expedient, require the suspect to permit a search of any article he has with him, and 2, to permit a search of his person, and B, for the purpose of exercising his power under subparagraph A2, detain the suspect for so long as is necessary for the exercise of that power. Subsection 3. The powers conferred by this section are exercisable only so far as reasonably required for the purpose of finding cash. And this section does not require a person to submit to an intimate search. So that is an important constraint on the powers of a police officer or a customs officer in terms of the ability to conduct a search and what the search ought not to be. It ought not to be a search at large. It has to be directed to a certain purpose, and it is not permissive of an intimate search. And we will come very shortly to the rationale for these restrictions. Subsection 4. The powers conferred under this section may be exercised only with the prior approval of a senior police officer, unless in the circumstances it is not practicable to obtain the authority before exercising the power. Subsection 5. Where the powers conferred under this section are exercised without prior approval, as required by subsection 4, the police officer exercising the power shall make a written report to a senior officer as soon as is reasonably practicable. And in the interest of time, I shall not read subsection 6. Subsection 6 mandates what should be contained in that written report. So, who is entitled to search? It is not a police officer alone. It is a police officer and a customs officer, and that comes from the interpretation section, section 2.1 of POCO. And it is a police officer who is lawfully on the premises and who has reasonable grounds for suspecting that there is recoverable cash on the premises. So there are 3 well-established conditions precedent that must be fulfilled before the officer is able to search a property for cash. He must be lawfully on the premises, that is the first prerequisite. Secondly, he must have reasonable grounds for suspecting. And thirdly, the reasonable grounds for suspecting cannot be at large, but they must relate to the existence of recoverable cash on the premises. So it must be a suspicion directed to something very specific. That is the existence of reasonable cash on the premises. Let us turn now to that well-worn term. What are reasonable grounds for suspecting? Reasonable grounds for suspecting, it is a term used, a term of art that is well known in the criminal law. And one of the best definitions that I have found, and that is fully applicable to your POCO, would be one coming out of the case of O'Hara and Chief Constable of the Royal Ulster Constabulary, a decision of 1997. Again, in the interest of time, and given that you will also have access to these slides after the presentation today, and you will also be given electronic copies of all the cases that I have referred to in my presentation, I am not going to go into the facts of the case, of this case. Suffice it to say that although the facts are different, and this case related to a homicide, so it's a different factual matrix, that does not change the applicability of the terminology of what is a reasonable, or what can constitute a reasonable ground for suspecting. Is it a subjective test? Is it an objective test? Or is it a two-pronged test? And I think we already know the answer to that question. It is captured in the second bullet point under the substance of the case. In that case, the House of Lords opined that reasonable grounds for suspecting relates entirely to what is in the mind of the officer when a power is exercised. The House explained that it is in part a subjective test because the officer must have formed a genuine suspicion in his own mind that the person has been connected with certain acts. In part, it is also an objective one because there must also be reasonable grounds for the suspicion which he has formed. So it's a double-barreled test. In essence, there must be sufficient material from which an inference could be drawn that the officer had reasonable grounds for his suspicion. It must constitute information known to him, though not necessarily from his own observation. He's entitled to form an opinion from what he has been told, and it is not necessary to prove that he proved any of the facts on which his suspicions were based, or that he proved that those suspicions were true. And I would refer you in this regard to the well-known text, Criminal Practice and Procedure, the 3rd edition by Dana Sitahan, at page 34. What are some of the restrictions that are imposed on a police officer or customs officer in searching an individual or his property? Sections 105, subsections 3, 4, 5, and 6 of POCO are germane. 105.3, which we have dealt with before, said that the powers conferred are exercisable only as far as reasonably required for the purpose of finding cash. So we have already discussed that it must be a suspicion that is generated or directed to a specific purpose. Subsection 4 mandates that it is a power that is exercisable only with the prior approval of a senior police officer, unless it is not practicable to obtain that authority before the exercise of the power. And if the authority is exercised before the opportunity to obtain the sanction of a senior police officer, then the police officer or customs officer has to write up a report documenting and substantiating why he or she went ahead. Why do you think, and I'm going to throw this question out, please, and I'm going to respectfully ask for some audience engagement here. Please don't be bashful. Why do you think the ordinance has these restrictions? Why are there these provisos and riders? Is there anything that obviously comes to mind? Anyone?
Is there a risk of overreach?
The risk of overreach, yes. So it's a form of control. Anyone else? The risk of overreach connected to what issue? Are there constitutional issues implicated here? Right?
Yes, I was thinking the right to your property. So you
Right.
have right to property.
Yes, so right to property. Ms. Ferguson has also said, just to repeat her response as well, that the cash may have come into his possession through legitimate means. So there must be an element of caution and proportionality. I gather that is the point being made. So all those would be correct responses. But what looms large to me are the constitutional facets involved. POCO is undoubtedly a draconian ordinance, which has the potential to deprive the individual of his property, in this case, his cash, contrary specifically to sections 9 and 17 of the Turks and Caicos Islands Constitution, protection for private and family life, and for privacy of home and other property, and the peaceful enjoyment of property, and protection from the deprivation of property. So there are serious constitutional ramifications or potential ramifications, I should more accurately say. As such, there must be built-in constitutional safeguards and guardrails against the wanton use of such onerous and draconian powers. The requirement for there to be some reasonable requirement is one such safeguard. And a reasonable requirement is just another way of synonymously introducing a concept of proportionality, I would suggest, without being overly technical about the concept of proportionality. Secondly, an important restriction is that in searching persons, the ordinance does not permit intimate searches, because that may prima facie amount to derogation from Section 9 of the Constitution, which states that no person shall be subject to the search of his or her person. The need for the prior approval of a senior officer, again, must be looked at against the constitutional safeguards, but it is also of practical utility. The senior police officer may be able to better gauge by dint of experience whether the officer has met or is capable of meeting the statutory requirements to exercise the searching powers. So he would be able to cast, with the benefit of greater years of experience, a more prudent eye perhaps a more sagacious eye over the evidential material gathered to ensure that it reaches a certain level of sufficiency that would properly found an application, as opposed to being what is commonly termed a fishing expedition, which we have to guard against at all costs. So it's a practical measure as well. And finally, the need to report is also the converse of that. It is practical. It's a contemporaneous document which justifies the use of the onerous search powers and ensures that the police or customs officer possesses the prerequisites necessary to conduct a search. And if he is unable to get the sanction before, he must account and explain with a sufficient degree of particularity, which is subject to scrutiny, why he has been unable to do so, and why he thought it necessary to proceed in the absence of getting the sanction of a senior police officer. So it is important in the interest of, I would suggest, first and foremost, the rule of law, and in the interest of ensuring accountability and also its brother, transparency. So, seizure, we turn now, we have dealt with searches of property, searches of persons. Let us look at the second aspect, which deals with the seizure of cash under POCO. Section 106 provides that a police officer shall seize cash if he has reasonable grounds for suspecting that A, it is recoverable cash, or B, part of the cash is recoverable cash, and it is not reasonably practicable to seize only that part. After a seizure is made by a police officer under this section, that is 106 subsection 2, the police, or in the case of a customs officer, the collector of customs, shall promptly, and in any event within 24 hours of the seizure, all my emphasis, report that seizure to the financial crime unit. So, the prerequisites for seizing cash under 106 of POCO are these three. There must be reasonable grounds for suspecting, 2, that it is recoverable cash or that recoverable cash is involved, or that part of the cash is recoverable cash, and it is not reasonably practicable to seize only that part, and that therefore the entire amount of cash has to be seized. The concept of reasonable ground for suspecting, the test is self-evidently the same, the two-pronged test that was articulated in O'Hara against Chief Constable of the Royal Ulster Constabulary, which I commend for your reading and which I indicated you will have an e-copy of at the end of today's hearing, today's session. So, what are some examples of reasonable grounds for suspecting? And rather than being examples, these are some bases upon which a police officer or a customs officer may have a reasonable grounds for suspecting. A proviso to this would involve me telling you that this list is not a prescriptive one, and it is not intended to suggest that any particular category is preferable in preference to the other. Can we go back to the other slide, please? Right. So, an example of evidence that might found a reasonable ground for such suspicion might be a failure to disclose a significant sum of money to customs officials upon entry into your jurisdiction. Again, your jurisdiction is a major tourist hub. So this may be a particular issue with the customs. Based on tip-offs, that would be enough under the UK case to justify a police officer in having a suspicion. Suspicious or shady behavior and demeanor. Now, I don't want you to misapprehend what I say here. What I think may be shady behavior may not be what you think is shady behavior. We all have different norms where that is concerned. So if one leaves it up to police officers to determine what constitutes shady behavior and shady demeanor, I don't think, speaking for myself, that any of us will be too happy with that. So please do not focus on this factor in isolation. I mean it as a bit of circumstantial evidence that the police officers or the customs officer may want to look at in founding whether there is a reasonable ground for suspicion. Association with persons involved in illicit activities. Coming out of the jurisdiction of Jamaica, as my sister Justice Brown-Antoine said, from which many important cases come. Inconsistencies in the description of the source of the cash or why it was present where it was found. And that comes out of the decision in Sandra Marie Cavalier and the Commissioner of Customs, which will be made available to you. And untruthful explanations as to the use of the funds. Again, a decision 2014 out of Jamaica, Leroy Smith against the Commissioner of Customs. So these would be some examples. Now, what is recoverable cash? Because we keep coming back to the terms, core terms, recoverable cash and recoverable property when we are dealing with Part 3 of the Act and civil recovery. Under Section 104, subsection 1 of POCO, recoverable cash is defined in the following way. Cash which is recoverable property or is intended by any person for use in unlawful conduct, and the amount of the cash is not less than the minimum amount. So that turns us to what is recoverable property, because recoverable cash is referable to what is recoverable property. Section 62 of POCO defines recoverable property in subsection 1 as property obtained through unlawful conduct, and tainted property is recoverable property. Subsection 2 of section 62, property obtained through unlawful conduct that has been disposed of since it was obtained through unlawful conduct, or tainted property that has been disposed of since it became tainted property, is recoverable property if it is held by a person into whose hands it may be followed. And I would just like us to go through subsection 2 again. Property obtained, bearing in mind Justice Brown-Antoine's disposition on money laundering and the whole concept of following the money and being able to trace and track the money. And bearing in mind the reality of money laundering, which is that very often the benefit that is derived may be far removed from the actual offense. Property obtained through unlawful conduct that has been disposed of since it was obtained through unlawful conduct, or tainted property that has been disposed of since it became tainted property, is recoverable property if it is held by a person into whose hands it may be followed. That means that even if the property has been laundered and has become clean and is removed in point in time by the process of laundering, once it can be followed, it can still fall, it can still be subsumed within the definition of recoverable property. One of the issues involved here is, of course, the issue of the police officers and the DPP's office to be able to engage in very astute evidence gathering so as to be able to prove these sorts of offenses, both in terms of money laundering, and to be able to conduct an effective civil asset recovery scheme. Because this is only, your legislation is only as good as your police officers are and as the competencies of your prosecutors are, respectfully. And I have no reason to doubt their level of competency. But these investigations have the capacity to be very, very complicated. And it's important that they be very meticulous. So that's a point that must be underscored. So what is unlawful conduct? Because again, recoverable cash is tied into what is recoverable property, which is tied into what constitutes unlawful conduct. Unlawful conduct has a very broad definition under POCO. Under Section 60 of POCO, unlawful conduct is defined as conduct which, A, if it occurs in the islands, is unlawful under the criminal law of the islands, or B, if it occurs in a country outside the islands. And BI, 1, it is unlawful under the criminal law of that country. And 2, if it occurred in the islands, would be unlawful under the criminal law of the islands. So let us pause on this slide for a while, just to digest how very sweeping, how very all-encompassing the definition of unlawful conduct is. We are not dealing with specified offenses which come under a different section of your Proceeds of Crime Ordinance, which I had indicated time does not allow me to go into that section 13 and ongoing. We are dealing purely here with civil recovery. And under civil recovery, unlawful conduct is conduct which is unlawful under the law of your islands, or if it occurs in a country outside your islands, but would be unlawful under the criminal law of the country where it occurred, and had it occurred in the Turks and Caicos, it would be also unlawful under the criminal law of your islands. Not unlike that well-known condition in extradition law that you would know as well too, that it must constitute an offense under both jurisdictions, the jurisdiction that is seeking the return of the fugitive offender and the offense in which he is seeks to be has fled to. Recoverable cash is therefore a form of recoverable property which has been obtained by or through unlawful or illegal conduct, such as the commission of any criminal infraction. And recoverable cash could also be a species of tainted property. Section 59 defines tainted property as property that A, has been used in or in connection with unlawful conduct, or B, is intended to be used in or in connection with unlawful conduct. Recoverable cash could thus be cash which has been used in or in connection with, or which is intended to be used in or in connection with unlawful conduct. Now, there was a proviso that it must be of an amount that is more than the minimum amount. So what is the minimum amount? Regulation 31 of your Anti-Money Laundering and Prevention of Terrorist Financing Regulations of 2010 provides under Regulation 31. And I will refer you only to 31D under definition of recoverable cash under Section 106 of the ordinance. The amount prescribed is $250. So the minimum amount is therefore $250. It must be over $250. So that's the only proviso. Okay. You move on. Before we move on from this issue, which is worth your while, I think respectfully, I say this with the rider that I'm unsure whether this decision might be the subject of an appeal to the CCJ. So this might not constitute the final word on the subject. I'm unaware of whether there's an appeal pending, but there may be. But there is a decision of the Court of Appeal of the Eastern Caribbean Supreme Court in the decision of Peter Hippolyte and Magistrate Bertlin Reynolds, a very recent decision in 2024, delivered just a few months ago. And the facts are interesting. The respondents had been arrested following the search of a vehicle. And the search had revealed a sum of foreign currency. The cash was seized and retained by the police, with a then acting corporal charging the respondents with unlawful possession of the cash in 2010. The police retained the cash pursuant to the criminal proceedings. The respondents challenged the constitutionality of the section under which they were charged, and the charges were discontinued. Subsequently, in 2019, WPC, acting in her capacity as a financial investigator of the Financial Intelligence Authority, and on behalf of the director of the FIA, formally seized the cash pursuant to Section 29A of the St. Lucian POCA. She then applied for a continued detention order, which was granted by the magistrate. And up to this date, the cash had been in the possession of the police for almost 9 years. Eventually, the respondents filed an application for the release of the cash. A magistrate refused that application. The respondents sought judicial review of the magistrate's decision. And dissatisfied with the decision of the judge, the appellants appealed. Two issues that arose on appeal, or the two issues, the two primary issues, were whether the magistrate acted ultra vires poker when she granted a continued detention order, and secondly, whether the police were in lawful possession of the cash between the period the 1st of January 2019 and the 23rd of April 2019, consequent upon the prosecution's discontinuance of the criminal process, and whether this was a relevant consideration of the magistrate in arriving at her decision to grant the continued detention order. The Court of Appeal opined on what was meant by seizure under Section 25, and in the interest of time, I'm not going to read Section 25, I'm going to go into the other slide. As to who who has to possess the reasonable grounds for suspecting. At paragraph 39 of the judgment of the Court of Appeal, the Court of Appeal said, to put it simply, the learned judge erred in his interpretation of Section 29A of the POCA in finding that anything more than reasonable grounds for suspecting that cash seized under the section where the proceeds of criminal conduct was required. The POCA does not include any requirement that the reasonable grounds or reasonable suspicion be that of the seizing officer only. In fact, it was likely contemplated that financial investigators, who are not all police officers, would be operating on the evidence presented to them by police officers who may have previously seized the cash, or who, through their own investigations, have reason to believe that the cash represents proceeds of criminal conduct. If the financial investigator is satisfied on the basis of that evidence that there are reasonable grounds for such a suspicion, that is sufficient for the purposes of the POCA. Section 19 requires nothing further, and certainly not to the degree that the learned judge has suggested. And the Court of Appeal went back to the factual matrix of the case. The facts of this case, in short, were that the respondents were found in a vehicle in the early hours of the morning, carrying almost 1 million EC in foreign currencies. Based on these circumstances and the additional evidence of the original seizing officers, there was enough evidence for WPC Jules to form her own reasonable suspicion that the cash formed the proceeds of criminal conduct, and the learned judge erred in substituting his assessment for that of the magistrate, and in finding otherwise a court not open to him, a course not open to him on review. So a case to look at in your own time. After seizure has taken place, the police or customs officer must promptly or within 24 hours report that seizure to the Financial Crimes Unit under 106(1) of POCO. We turn now to another phase. We have dealt with searches of property, searches of persons. We have dealt with seizures. We go on now to the subject areas of detention and continued detention. Detention. Under Section 107 of POCO, it stipulates that while a police officer who has seized cash under Section 106(1) continues to have reasonable grounds for his suspicion, the cash seized under that section may be detained initially for a period of 72 hours, excluding public holidays and weekends. So what are our three preconditions here? That it must be a police officer or customs officer who has seized the cash, that that officer must continue to have reasonable grounds for his suspicion, that the cash seized may be detained initially for a period of 72 hours, I am going to throw out at this stage, before turning to the other slide, a very quick question. Do you think that it is sufficient for a police officer or customs officer merely to depose that he has reasonable grounds for suspicion? Or do you think that he must disclose with some level of particularity what is the evidential basis for his continuing to have reasonable suspicion? That's the first question. And the corollary to that is, should there be cross-examination facilitated on that issue so that defense attorney can probe whether there continues to be reasonable suspicion so as to found an extension of the detention? Any quick responses? Again, I know it's coming up to lunch, but don't be bashful, excuse me. He should articulate his subject and be his suspicion and be subject, I'm sorry, to cross-examination. I entirely agree. In fact, there's a decision in Trinidad and Tobago which says precisely that, which we will come to momentarily. Yes, it is important because one is dealing, again, with matters which impact upon constitutional rights, and we must not lose sight of this. And because certain time frames are involved, so we must always bear in mind that generic statements are not going to suffice, that the officer has to condescend to particulars, and that due process involves according defense opportunity, a proper and meaningful opportunity to engage in probing and testing the veracity and the reliability of the evidence of the police officer or the customs officer. There must be strict compliance with the time period for detention, that is 72 hours. And I cannot emphasize this point strongly enough. There's no flexibility in this regard. Coming out of the decision in the Queen and Uxbridge Magistrates Court ex parte Henry, a decision of 1994, a judgment of Justice Scott Baker, this was said: Parliament, in my judgment, has prescribed a specifically limited period, a period to be measured in hours. This is, as the learned editors of Archwold have pointed out, this is draconian legislation. In these circumstances, it is particularly important that its provision should be strictly complied with. 48 hours is the period given to the Customs and Excise to make their further inquiries. And if they require more time, then they have to go to a magistrate to seek an appropriate order. It does not seem to me that that places any undue burden upon them. Before going to the next slide, which reinforces that point in a very poignant way, again, because one is dealing with draconian legislation, which potentially impinges upon constitutional rights, time periods must be strictly adhered to. But now, I know the font is very small, but again, the interest of time don't allow me to go through the case of Catherine Walsh against Customs and Excise, but essentially the same point is made, and it comes out at paragraph 21, that there must be strict adherence to the timelines involved. Turning to the next slide. Section 107, 2 and 3 of POCO speak to applications for the further detention of cash. Subsection 2 says the period for which cash or any part of it may be detained may be extended by an order made by the magistrate's court. But the order may not authorize the detention of any of the cash beyond the end of the period of 3 months beginning with the date of the order, or in the case of any further order under this section, beyond the end of the period of 2 years beginning with the date of the first order. So, an application for an order under subsection 2 may be made by a senior police officer to the magistrate's court, and the magistrate's court may make the order if satisfied that these conditions are satisfied, that there are reasonable grounds for suspecting that the cash is recoverable cash, that is, its continued detention is justified while its derivation is further investigated, or consideration is given to bringing proceedings, whether in or outside the islands, against any person for an offense with which the cash is connected, or B, proceedings against any person for an offense with which the cash is connected have been started and have not been concluded. Before we move on from subsection 3, I would just like to take us back to subsection 2, please. I refer you again to subsection 2 of 107 of your POCO, which says, in the case of any further order under this section, beyond the end of the period of 2 years, beginning with the date of the first order. And we can continue. Well, so if there are reasonable grounds for suspecting that the cash is intended to be used in unlawful conduct, and either that its continued detention is justified, while its intended use is further investigated, or consideration is given to bringing proceedings, whether in or outside the islands, against any person for an offense with which the cash is connected, or proceedings against any person for an offense with which the cash is connected have been started and have not been concluded, the application may be made. The question that I would like to throw out to you is, in your view, given the provisions of POCO that we have just gone through, can a magistrate grant an application for further detention where proceedings against any person for an offense with which the cash is connected have been started but have not been concluded within 2 years? Or would that be, yeah, but I see an answer came up immediately. Okay, so Ms. Ferguson says no. Does is that the consensus view, or rather I should ask, is there anyone of a different view? Anyone of a different view? Can I take
it depends.
Yes, sir.
It depends on if they continue to provide the evidence. I think that's what I want to say.
Yes, but bearing in mind the provisions, if we can go back to that section, just one moment. Let's go back to 2. 107.2 says the period for which the cash or any part of it may be detained may be extended by an order made by the magistrate's court. We skip out A, we go to B. In the case of any further order under this section, beyond the end of the period of 2 years beginning with the date of the first order. And then we go to subsection 3, which in my view has to be read subject to subsection 2. So you are saying, sir, that it would depend on the caliber of evidence that the customs or the police officer brings.
Yes,
yes?
but because of 2B, I may want to change my answer.
You may want to change your answer. Okay. My respectful view, again, subject to any further discussion that you may want to have on it this afternoon, is that if the proceedings have started, they can be adjourned. From Mr. Mitchell. Mr. Mitchell, would you care to elaborate on that very briefly, please?
Sorry, yes, of course. If the application for forfeiture has started because there's prima facie evidence, then the proceedings could be adjourned and they would avoid the 2-year embargo because the process of forfeiture has begun. Rather than seeking detention for the purposes of, the process will have begun, which would permit the court to adjourn the case in the normal course. So I think this 2-year, the 2-year conclusion is where the process of forfeiture, the application for forfeiture, has yet to be brought.
But Mr. Mitchell, could I ask you, might that not be provide an opportunity for potential abuse?
Well, it depends. It entirely depends on that. That's going to be a matter outside the process, which you are, if I may say so, delivering clearly and concisely on, and thank you for that, but is part of the process which the magistrate would have to determine in the course of his or her jurisdiction. I mean, plainly, an applicant for forfeiture who is seen simply to have brought the process and can't put up before the court what the material is to proceed with the forfeiture is going to have the case dismissed. But a process of forfeiture that begins, that is capable of supporting before the magistrate arguments as to evidence, acts availability, and the process which is being undertaken, would be one which the magistrate would, I would suggest, be likely to allow to continue if progress is being made. But that is outside the context of the legislation. That's much more an issue of
Yes.
process in the court.
Yes, that's understood. Thank you for that perspective, Mr. Mitchell. So we are going to leave off giving a categorical answer to this question. We may want to come back to it this afternoon if time permits. And I'm just going to refer you to an English decision which may be helpful. It's a decision in Man 2021, England and Wales High Court, where the Queen's Bench Division considered Section 295, subsection 2 of poker, which is substantially similar to your Section 107.2. Man was a case in which a first detention order had been made under Section 2942A of poker on the 3rd of October 2019 for a period of 6 months. And this was due to expire on the 3rd of April 2020. Because of the onset of the lockdowns at the start of the COVID pandemic, no hearing took place until the 22nd of June. District Judge Green held that she had no jurisdiction to order the continued detention of the cash beyond the expiration of the first 6-month period of detention. And in giving a judgment in that case, Justice Kavanaugh agreed. Lord Justice Bean said that, moreover, even if the matter were free from authority, it seems to me that the construction for which was contended for in the present case is contrary to the natural meaning of the statute. Section 2952 uses the word extended. I do not accept that Parliament was using the word in anything other than its natural meaning, which is that the decision must be made before the original period expires. Otherwise, the so-called extension is retrospective. Lord Justice Bean also said, he referred to some of the submissions made. Mr. Rainsbury submits that the provisions and the sections of the 2000 Act were referred to, which allegedly supported Mr. Rainsbury's case. But with respect, I consider that they're clearly against it. In Section 2982, Parliament provided that when an application for forfeiture has been made to a magistrate's court, the cash is to be detained until further proceedings are concluded. When the forfeiture by notice procedure was introduced by the 2009 Act, a similar provision was made in Section 29D5, but neither in 2002 nor in 2009 did Parliament make any amendment to Section 292 to ensure that when an application is made for an order under 2952, extending the period for which cash may be detained, the same kind of holding provision should apply. Parliament, in my view, must therefore be taken to have been content with a strict approach, which this court has taken in the cases of Henry and Walsh to statutory powers, which, though not identically worded, are not material. So we're going to hold off on a definitive answer to this question. There may be no hard and fast answer, and perhaps come back to it this afternoon and proceed to forfeiture at this stage. In the interest of time. Under Section 110 of POCO, it provides, in terms of forfeiture, that while cash is detained under Section 107, an application for the forfeiture of the whole or any part of it may be made to the magistrate's court by a police officer. Subsection 2, the magistrate's court may order the forfeiture of the cash or any part of it if satisfied that the cash or part A is recoverable cash, or B is intended by any person for use in unlawful conduct. So, an application for an applicant for forfeiture must satisfy the magistrate that the cash or any part of it is recoverable cash or is intended to be used in unlawful conduct. And we have seen how broadly framed unlawful conduct is in POCO. Now, this is a low threshold, and by low, I mean low in terms of the standard of POCO, the civil standard, that is required to satisfy the magistrate. It is certainly not low evidentially, and I don't want you to misconstrue it in that way. The evidence to support it may be quite care, meticulous care has to be taken in marshalling that evidence. The cash must be detained until all the proceedings relating to the application for forfeiture is finally resolved, including any appeals. Moving on, what happens to the forfeited cash? Under Section 112 of POCO, after the period within which an appeal under Section 111 may be made, if a person appeals under Section 111, after the appeal has been determined or disposed of, cash forfeited under Section 110 and any accrued interest on it shall be paid into the fund. The fund is termed the National Forfeiture Fund, and that comes out of Section 152. Now, in the remaining 5 minutes, as I proceed into wrapping up my presentation, with your kind indulgence, knowing that I'm encroaching very slightly into your lunch break, and I don't want to incur your wrath, I would wish to make some very respectful observations concerning the possible consideration of the implementation of an unexplained wealth system. It is well known that your islands are an international financial center in the Caribbean. My sister adverted to a certain report, and in December of 2021, the Honorable Attorney General, the Honorable Knowles QC, explained that one of the goals of the TCI is to be a secure and well-regulated international financial center, which is effective in mitigating against money laundering, terrorist financing, and proliferation financing. And that comes out of the National Anti-Money Laundering and Combating Terrorist Financing and Proliferation Financing Strategy report of 2021 to 2023. To that end, your island's Anti-Money Laundering Committee, with the approval of the Cabinet, agreed the AMLC strategic plan for the period 2020 to 23, which sets out the vision and strategic objectives of the AMLC over that period. And that involves stakeholders undertaking further actions necessary to improve the framework and to reduce the island's vulnerability. And Justice Brown-Antoine spoke as to one of the geographical reasons as to why you are vulnerable, because of your location as a transshipment point, and also because of your nature as an archipelago as well too. And also steps that would be proactively taken to strengthen your financial sector from abuse by criminals. Two of the strategic priorities of the AMLC are effectively deterring, detecting and disrupting money laundering, terrorist financing, and proliferation financing, and maintaining public confidence in the TCI as a well-regulated international financial services center. Bearing that in mind, the TCI's government has no doubt progressively enhanced its legislative framework and developed various policies, procedures, and guidance in respect of AML to keep abreast of various changes and developments. But are there any gaps that need to be interrogated? Are there any jurisdictions which have been able to broaden their capture of illicitly obtained wealth in a way that is proving to be promising and or effective? And I am going to suggest that there may be an advantage in looking at some jurisdictions. I'm going to respectfully suggest that a key way in which your islands can continue your effective methodology of deterrence, detection, and disruption of both money laundering and terrorist financing threats is through the implementation of an unexplained wealth system. And what is an unexplained wealth system? It diversifies the asset recovery arsenal It is typically an investigative and confiscation procedure that requires persons to show how they obtain certain property once authorities have shown that it is not commensurate with their lawfully obtained incomes and assets. And it may apply to any person, including legally persons or specifically targeted politically exposed persons. If the concerned person does not justify the legitimate origin of the assets, confiscation may be ordered, even if a link between the asset and a crime is not established. Most unexplained wealth orders are based on the same essential concept. The authorities are not required to prove that assets are derived from a crime, and that confiscation is based rather on a discrepancy between a person's legitimate income or wealth and the person's observed wealth. And in countries that have established UOs, as they are called, this tool is based on a civil rather than a criminal action, and hence standards of civil procedure apply. In some countries, the action includes its own recovery power that allows the authority to confiscate to the extent that it cannot be explained the property in question, or require the individual to pay the difference between that which can be accounted for and that which cannot be accounted for after due process has been adhered to. In 2017, the United Kingdom introduced its UO law. In my jurisdiction in 2019, the UO framework was established with a two-step procedure. One, a preliminary unexplained wealth order, an order to explain, followed by a potential unexplained wealth order, which was an order to pay the unexplained amount, which was similar to Australia's federal approach. In 2019, Barbados introduced a UO framework in its Proceeds and Instrumentalities of Crime Act of 2019. There, I would suggest multiple advantages to the implementation of an unexplained wealth system. And some of these advantages are as follows. First, the system can help fill gaps and increases the scope and impact of asset recovery. I'm just going to look at the headings. Secondly, it can boost asset recovery by reinforcing investigations and confiscation systems. Thirdly, it supports the integrity of major financial markets and counters specific reputational risks for a financial center. And in this regard, just to take the example of the United Kingdom, one aspect of insufficient asset recovery had been that prior to the implementation of UOs, that country was at risk of being perceived being a haven for corrupt individuals and their ill-obtained assets. And the UK recognized this as a threat to the integrity and reputation of its financial markets and implemented the scheme. So it's important for any jurisdiction that faces a similar risk or thinks that such a risk may be imminent to perhaps have discussion at an appropriate level about the need to broaden its capture and to reinforce its support financial markets and restore confidence in them. In Trinidad and Tobago, the interest of time do not permit, but the authority would be sent to you a decision in the case of Police Officer Wendell Lucas and David Niranjan, which was a case which dealt with a preliminary unexplained wealth order. And the essential takeaway from that case is that much depends on the quality of the police investigative work that is done, the work that is done by the police investigative officer. In that case, the Court of Appeal explained the Unexplained Wealth Act creates a civil asset forfeiture regime, which is geared towards preventing unjust enrichment. The foundational jurisprudential framework of the UW Act is that it allows the investigator to take account of the monetary value of illegally obtained assets wherever they have gone and in whoever's possession they end up, regardless of whether that person has committed the specified offense. When examined as a whole, the UW Act implicitly recognizes the reality that the essence of money laundering is that the benefit is likely to be far removed from the commission of the offense and sometimes from the person who committed the offense. In that decision, the point was made that the UW Act could not be evaluated in isolation. It had to be looked at together with poker. So in that decision, we commented at paragraph 63, it constitutes part of interconnected legislation of which the poker is integral. While the UW Act pursues well, with no need for conviction, the poker regime is conviction-based and pursues the person who has committed the specified offense and the benefit obtained from the commission of the offense. The offender is liable to be convicted of the specified offense and the benefit taken away post-conviction through the process of seizure, forfeiture, or confiscation. Finally, this critical point was made in the decision of the Court of Appeal of Trinidad and Tobago. Civil asset forfeiture rests on the legal fiction that the property and not the owner that has committed the offense. This concept has certain repercussions in the discussions on the issue of retrospectivity, since it carries with it the established legal fiction that the property continues to remain so. And the decision of the South African Constitutional Court was referred to in Profit Against National DPP 2006, that civil forfeiture provides a unique remedy used as a measure to combat organized crime. And this is civil asset forfeiture in the broadest sense of the term. It rests on the legal fiction that the property and not the owner has contravened the law. It does not require a conviction or even a criminal charge against the owner. This kind of forfeiture is in theory seen as remedial and not punitive. So in my respectful view, the implementation of an unexplained wealth order system is at least worth discussion and might redound to the benefit of the already robust actions that have been adopted by the TCI in reinforcing their legislative framework and the other very commendable work that you have done. So are there any questions at this stage, or would you prefer to hold over any questions until after lunch? I leave it entirely up to you.
Hi, good morning, Judge. Thank you very much for that presentation. I think in the interest of time, we hold over the questions until after lunch.
Yes.
All right, so just letting everyone know that in the chat as well, I've just shared a case study, which Justice Carla Brown-Antoine has asked me to share with everyone. Judge has asked that everyone reviews the case study over the lunch break and that we can engage in discussions with it at this afternoon's seminar. I'd also like everyone to know that this afternoon seminar will begin at 1:40 p.m. So I'm thanking everyone for their attendance this morning. And before we close, I'd like to acknowledge as well the attendance of the National AML Coordinator, Mr. Kerry Lucio, who perhaps can speak on the work that the Attorney General's Chambers is doing this afternoon. So good afternoon, Mr. Lucio. All right, so good afternoon, everyone, and we look forward to your attendance this afternoon. Thank you very much. Hi, good afternoon, everyone. Welcome back to today's presentation on anti-money laundering. I hope everyone had a good lunch. I'd just like to confirm that everyone can hear me.
Yes.
Yes, I can hear you.
Okay, excellent. So I now hand us back over to Justice Carla Brown-Antoine and Justice Mohammed.
Yes. All right. Good afternoon, everyone. I don't know if Justice Mohammed wants to just complete his presentation before we take a look at the case study.
Thanks, Justice Brown-Antoine. No, I had wrapped up the presentation and I had said that if there were any questions that needed to be asked, then perhaps this afternoon might have been the appropriate time. And I believe Antonio had endorsed that as well.
Yes. All right. Yes. All right. Thank you. All right. So everyone would have received the case study. And what I hope to do is to generate some discussion on the case study with respect to money laundering offenses in the Turks and Caicos Islands. So I don't know if by asking some questions. So hopefully everyone has read. I know it's a bit long, but I try to give as much detail as would assist with the issue of money laundering. So it's all about discussion. And so I hope that people will share their views with respect to the facts in outlining the case study. The first thing that I want to ask is, what was the criminal property? Does anybody have a view as to what the criminal property might be in the case study? Or do you Yes. So, Ms. Ferguson, I would prefer if you would unmute your mic and turn on your camera and engage with us. Yes? Thank you.
Hello, Madam. Good afternoon, everyone.
Yeah.
I was saying that I think the criminal property is the money moved between accounts.
The?
Money,
Which in particular? Which money in particular are you talking about? The money sent? Yeah, you tell me.
the money that, I'm sorry, that was found across the 7 different debit cards that had been issued. So the money is on the in the Bank of Baroda and the HSBC account, the Royal Bank account, the monies that were contained in those accounts.
You see, all the monies contained in those accounts are criminal property, yeah?
Yes, Madam.
All right, thank you. Anybody agrees or disagree? Anybody has a different view?
Madam Justice of Appeal, it's Andrew Mitchell here.
Yes, hi, yes, thank you.
And how are you?
I'm good, I'm good.
I'm sorry to say that whatever it was that we were supposed to have, I haven't got. And as
Oh.
quickly as I would love to read it to make, if I have any contributions, I'm rather limited. And I don't know whether the silence is because others have are in the same position.
Okay, thank you for raising that point, Mr. Mitchell. So can I ask Mr. Emmanuel if you can reshare the document in the chat once more?
Yes, certainly. Thank you, Mr. Mitchell.
He's going to share it. It's quite long. So while you read it, Mr. Mitchell, I'm going to ask, I'm sure not everyone is in your position, so that I will ask those who would have read it if they would be as brave as Ms. Ferguson and share their views. What about the vases? Are the vases criminal property? Let's. So it is in the chat.
Yes.
So you can. I know it's a bit long, so it'll take you about 5 minutes to read.
Justice Brown-Antoine, could I ask a question of Ms. Ferguson?
Yeah, sure.
Ms. Ferguson, could you substantiate your answer a little bit as to why you say the money transferred represented criminal property, that was criminal property? Just explain it to us a little bit.
Okay, yes, sir. I submit that the money is criminal property because of the definition in the Act, that is Section 122 of the Act, more specifically Section 122, subsection 1A, in that property is criminal property if it constitutes a person's benefit from criminal conduct, or it represents such a benefit in whole or part, and whether directly or indirectly. And I would go further to submit that the money that was passed between the accounts would, in my opinion, represent the benefit from the criminal conduct, that is, whatever was being transported in the vases, which was found to be cocaine. So it would be payment for receipt of the vases, and then it will be payment for the receipt of the vases, and thereafter changing the form of the torn paper into cocaine. So that is why I would say that the money is the criminal property.
Thank you.
So Ms. Ferguson, let me engage you a bit. What would be the evidence that the the prosecution would use to prove that the money in those accounts was criminal property?
I would say it is the irresistible inference that the monies can only be derived from crime or some criminal activity. And those inferences could be seen
Arise from which evidence?
Right. So the inferences arise from the evidence, which includes his being Mr. What's his name? By Mr. Mason, how he moved the money between the accounts. First of all, actually, the first big inference or the big clue I would say is the fact that his annual salary from his job prior to his arrest was just under 90,000 US per annum. But over the said 3-year period, an amount of $151,003.92 had been deposited into his other accounts that could not be attributed to his lawful employment. That's the first irresistible inference that I identified. And thereafter, the movement of the money in the accounts, secondly, it would be how the pattern of deposits, I believe it was written here, the pattern of deposits and withdrawals. So the withdrawals that were transacted overseas in Panama, Trinidad and Tobago, and Guyana, and the almost immediate deposit in the same or close amounts in his local bank accounts or to his local bank accounts. Thereafter, the way he treated with the money once it got into his accounts, he reported blocks placed on there, or he reported some issue with the cards, which caused for blocks to be placed on the accounts, and thereafter for new cards to be reissued. Yes, I'm sure there are other irresistible inferences.
Yes, from circumstantial evidence.
Yes, madam.
Let's see if anyone else add to the evidence, the circumstantial evidence Ms. Ferguson has identified that would permit the prosecution to say that the money in that account, the 3 accounts, constitute criminal property. Now, remembering that criminal property is a person's benefit from criminal conduct. So that's another way on which the prosecution can prove that the money in the account is criminal conduct, by proving that it's his benefit of criminal conduct. What's the criminal conduct the prosecution will rely on to establish that the money in those accounts arise from criminal conduct?
I have an answer.
Yes, sure, go ahead.
Would it be possession of equipment for the production of drugs, would that be the criminal conduct? That is, his being found in possession of the ammonia hydroxide, which is often used to transfer the drugs, or not
Was
transfer.
that the only thing he was found in possession of?
Yes, madam.
That was was that the only thing he was found in possession of?
No, and also there are vases discovered in his closet.
But possession of vases is not illegal.
But the vases had I believe, let me read again. They were found to contain the same torn paper that was tested and found to be cocaine.
Yes. And what about the cocaine that never arrived in the vases? What is the prosecution going to say about that? The ones that were taken out in the States and packaged separately, sent to Turks and Caicos, but they were never in the vases. He's not in possession of those, but what?
But he collected them in the same fashion that he had before. So he still went to collect the vases, and then thereafter he went to purchase the ammonia hydroxide. So he followed the same pattern, I would say.
Yeah. All right. Anybody else wants to weigh in on the cocaine that he never got or was taken out of the vases abroad? I know that Justice Pilgrim is on. I don't know if he wants to make a contribution. Not sure if he's still on.
Good day, Justice of Appeal, Brown-Antoine. I'm sorry, I haven't.
Oh, you
seen-
haven't read?
I cannot contribute, unfortunately.
Yes. Okay. You haven't read the case study?
No. I just saw it in the chat.
Oh, okay. All right. No problem. All right. Anybody who's read it? I know it's a bit long, but I try to provide as much information as possible. All right, so as not to take up dead air, the prosecution would be seeking to show, of course, the possession of the cocaine that was actually found in the vase that was there, and to make a connection by circumstantial evidence with the cocaine that was seized in the US. And the prosecution would be seeking to say that it's a pattern of behavior, a pattern of conduct. On a previous occasion, Mr. Mason and his co-accused, his co-conspirator would have imported these vases with cocaine, and they were attempting to do so on this occasion. Now remember, to prove criminal conduct, you have to prove an offense. The offense would be the possession of the cocaine which they were found with, but there's also an attempt to import the cocaine which was seized in the US. So that would be the criminal conduct, which the prosecution would seek to say is the prosecution would seek to say he was engaged in drug trafficking. That is the offense or the criminal conduct from which he derived a benefit, which amounted to the money in his bank accounts. All right, so let's get down to the meat of the matter now. Then how was the criminal property laundered? Anybody has a view?
I wish I could keep the it's Andrew Mitchell speaking. I wish I could keep the case study on my screen at the same time as I'm speaking to you, but every time I speak to you, it disappears. The money going out to Panama and the way that the money flows is obviously an example. But I think there were more, but I'd like to have had them both on the screen, but I don't. But if I find something else, I'll come back to you. Forgive me doing it in this way, but
Yes.
it's I've got it on my iPad, and I think it doesn't allow me to have both at the same time.
Yeah, okay, no problem. It seems that he was using the money to pay for the supply of cocaine, which was coming from Panama. I don't know if they proved any other use of the money in the account. Oh, yes, they did actually. I think that some of the money in the accounts was sometimes used for local purchases. So that if the prosecution alleged that the total amount of the money in those 3 accounts was the benefit of his criminal conduct, using it would amount to money laundering as well. His use of the money. Converting it, using it to purchase other things, using it to purchase more cocaine. That would be an offense under 126(1)(b). All right, so I've given it up. All right, so anyone wants to say whether he could be charged with money laundering offense based on these facts that I've presented? Can he be charged with money laundering offenses under the law of the Turks and Caicos Island?
Yes, madam.
Under which sections would he be charged?
Under section 124.
Which one of them? 124, which one?
124, I have concealing and disguising criminal property.
Concealing and disguising, all right. Anyone else has a different view?
Converting the criminal property through the local purchases.
Right, you have concealing, you have that disguising, and you have converting. Anyone else? Yeah, those are the 3 you see. All right, anyone else has another view? Someone says Miss Lucio. Is it Miss or Mr. Lucio? Not sure.
Mr. Ma'am.
Yes, so can you turn on your cameras, turn on your mic and engage with us?
Sure. Good afternoon, everyone.
Good afternoon.
And thank you to Ms. Ferguson for providing some really good responses. So I think there was some acquisition, use, and possession of the criminal property as well in his bank accounts. So he definitely possessed it while it was in his bank accounts. And if there were instances where funds were used to fund local purchases, then he would have used criminal property. What I find very interesting in this case also is the money laundering method, whereby the funds are in a domestic bank account, his bank account, but then there are ATM card purchases in Trinidad and Tobago and in Panama, thereby exposing a vulnerability that the financial sector has to money laundering and how persons abuse those financial services to further their crime. So I think that is very interesting, and I just want to congratulate the police one time for the controlled delivery. I thought it was a really good use of policing tactics. That's all.
A really good use of what?
Policing tactics.
Oh. Yes, this case had a lot of would you believe that this is an actual case?
From the facts, it sounds so.
There was a lot of evidence. The police were able to gather a lot of evidence.
But another interesting thing, ma'am, if I might add,
Yes.
is the consideration of property of corresponding value in a sense, because his salary to his bank account would be legitimate proceeds, right? The returns on his labor, but I concur that it will form part of the criminal property because he is using funds, the criminal funds, to fund his lifestyle, fund his expenses, and therefore the property that is within his account that might be from a legitimate source is property of corresponding value that we can go after to recover the proceeds of crime.
All right, so that's an interesting point. That's an interesting point. All right, so does anyone else want to make a contribution on this before I let you know what actually happened in the real case?
Madam, I would like to inquire about the bank personnel.
Yes.
So could the bank personnel also be found liable through Section 125 of the Act? That is that they, well, according to the case study, Madam, none of the banks, despite the many instances of blocks being imposed and removed, had any record of him ever reporting a concern of fraud or unauthorized incursion. Wouldn't that, Madam, be suspicion, some reasonable suspicion on their part to blow the whistle? Would they be liable in any way?
Oh, yeah, so I know under your act, there's somebody called a money, I think banks and financial institutions have to have a money laundering reporting officer. That's 128. Yes, so there, if we go to 128, where the money laundering reporting officer of financial business knows or suspects or has reasonable ground for knowing or suspecting that another person is engaged in money laundering. So it may be that the way he's conducting his business in the financial institution should have provided reasonable grounds for suspecting that he was engaged in money laundering. If they do, they're supposed to disclose the information to the Financial Intelligence Agency. So yes, it may be that the bank officials may be guilty of a breach of 128 of your laws. Maybe that they could be investigated for that. Because certainly the number of cards he has, the number of times he stopped them, and the fact that they said after, if it's during the investigation that they would have said, well, he would stop the card and then he would reactivate the card, but he would never make a report of fraud. Or never make a report of fraud. Is it that they only discovered that during the investigation and it never really occurred to them while he was doing it? You see, I mean, he wouldn't stop all the cards one time and reactivate them one time. He would do that over time. But I guess if they're monitoring his account, is that something that the bank would pick up? Or is it that it's something that they realized when the investigators came to them and asked them, and during the investigation, as it would? Yeah? I don't know. I don't work in a bank, so I don't know.
I think Mr. Lucio has an answer.
Yes, go ahead, Mr. Lucio.
Not sure if it's an answer, but a contribution. So I think you hit the nail on the head about the bank monitoring. So the bank has an obligation to conduct what's called CDD and KYC, which is customer due diligence and know your customer. So they have a duty to we've answered all of these questions when we go to open an account. So if they are appropriately applying their CDD, they should know their customer pretty well, know the source of income, know the transaction volume and the amount, the values that is normal over a period of time. And then they would risk rate that customer. If there are activities that goes outside of that norm, then again, if they are applying their AML policies, their compliance program properly, they should detect there is something here that's unusual, that's suspicious, forward that to the money laundering reporting officer to do a more in-depth analysis, and then onward to the FIA for investigation. In a situation like this, it's sometimes the case where during an official investigation by police, the Financial Services Commission, those are the ones that regulate the banks and the attorneys and the real estate entities. They would often go into the bank to do what's called an on-site examination to ensure that they are applying the rules appropriately. And if not, there is the potential for fines and penalties to be imposed, or even a criminal investigation if the bank is willfully complicit in the money laundering scheme.
Yeah, all right, thank you for that intervention, Mr. Lucio. All right, so I'm going to reveal now what the actual charges that were laid against. So this was an actual case in Bermuda. It's the case of Curtis Swan, and you will be Mr. Emmanuel is going to put in the chat now the actual charges that were laid against Mr. Swan in Bermuda. He was convicted, and his conviction was upheld on appeal. So he's going to put the actual charges that were laid and the decision in Curtis Swan. All right, so he was charged, Mr. Swan was charged with removing criminal property, as Ms. Ferguson did mention removing criminal property. So he was charged with removing criminal property from Bermuda, and he was charged with possession of criminal property, as Mr. Lucio said. Those were the two money laundering offenses that he was charged with. He was convicted. And he was also charged with offenses under the I think it's the Misuse of Drugs Act in Bermuda. So so you should have now the actual charges. So they did find that there was money laundering. He was convicted of money laundering, and he was also convicted of the offense under the Misuse of Drugs Act, and that is so thank you, Mr. Ferguson and Miss Ferguson and Mr. Lucio for your engagement. Yes, I hand over to Justice Mohammed.
Thank you, Judge. Justice Mohammed, you're muted.
Thank you. Were there any questions from this morning?
I had a question, sir.
Yes, ma'am.
With respect to, we were speaking about seizure of cash under POCO and what constitutes or examples of reasonable grounds, and one of them was a tip-off. And I was wondering, what are the effects, or what is the repercussion of a tip-off being wrong or malicious? Is the police or the customs officer then under duty to do further investigation into the tip-off before they can act on it or consider it to be a reasonable ground, or is the tip-off just taken as it is?
I would think that a tip-off should be taken with a degree of caution, and that is why I would link it back to the need to get the sanction of a senior police officer. I think acting on a tip-off alone could very well be misleading, so that there should be an attempt at some level of substantiation to ensure that there's some veracity in the tip-off, rather than simply acting on the face of the tip-off. So I wouldn't say that a tip-off alone would necessarily be sufficient. It may be a facet of the circumstantial evidence that would justify the application being made, but not in totality.
Thank you, sir. I had another question as it concerns a recoverable property. I was wondering what the consequence of tainted property is that cannot be followed. What recourse is there for tainted property that cannot be followed? And then further in your presentation, or later on in your presentation, you introduced the idea of an unexplained wealth system. I wondered if that could be one such recourse for tainted property that cannot be followed.
Yes. If tainted property cannot be properly followed, if the track cannot be properly followed, well, then the potential for recovery fails. Unexplained wealth is important in that regard, because once you can prove a discrepancy between the known income of the person and his style of living and his known income, then that allows you to cast a broader net. But once you cannot trace the tainted property properly, or if that trace fails at a certain point in time, then your entire line of inquiry fails. And therefore, the application, the substratum of the application would fall through. And that's where the unexplained wealth orders allows you to cast a much broader net.
Thank you, sir.
We have a question from Mr. Lucio.
Mr. Lucio?
Yes, thank you very much. On the point of the tainted property, I think this morning you're talking about criminal property and making its way into the hands of, tracing it into the hands of other persons. And that led me to think about the rights of bona fide third parties, and your thoughts on whether there is a bit of a limitation in that even if you were to trace criminal property into the hands of someone else, but the mere fact that that person would have purchased the criminal property for adequate consideration, then that would in fact sort of put an end to tracing, to considering that property as criminal property that would be subject to forfeiture or confiscation. The fact that it was acquired for adequate consideration.
Okay, could we just go back to this slide that deals with that issue? Just one more. Just bear with me. While I get this slide up, I don't think that the fact that someone has purchased for valuable consideration, a bona fide purchaser for value, I don't think that that should interrupt the train of the investigation, because that would defeat the very purpose of the money laundering investigation. And the section which I'm trying to pull up right now, which allows you to trace right through, even when the property falls into their hands, well, is no longer tainted. It has gone beyond the stage of tainted. And if we can get that section, please. Again, Mr. Lucio, bear with me.
Yes, I do realize this was slightly going off topic from car seizure, which is what your presentation was on, but it was the idea of tracing something onto the hands of someone else. I wanted to introduce that I've seen in other proceeds of crime acts in the Caribbean. So thank you very much.
We touched on it this morning. If we look at section 63 of your POCO, which is on the screen now, 63.1, where property obtained through unlawful conduct or tainted property, the original property is or has been recoverable property. Property which represents the original property is also recoverable property. If a person enters into a transaction by which he disposes of recoverable property, whether the original property or property which by virtue of this part represents the original property, and he obtains other property in place of it, the other property represents the original property. And subsection 3 was the section I was trying to locate on the slides, which we had gone through this morning. If a person disposes of recoverable property, which represents the original property, the property may be followed into the hands of the person who obtains it, and it continues to represent the original property. I would read the part of subsection 3, which says that the property may be followed into the hands of the person who obtains it, as being broad enough to include the bona fide purchaser for it. I don't know if that assists in answering your question, Mr. Lucio.
It does. It sure does. And I'm looking at section 126 under the acquisition, use, and possession for money laundering. 126 2C part 1. And thank you so much for indulging me, because I think that conversation kind of led me here. Where, yes, in 2C part 1, that even though the third party acquired that criminal property for adequate consideration and, of course, without knowing or suspecting the property was criminal property, that kind of brings an end. The financial investigator will still trace the property and then have to make a determination as to whether or not the property was disposed of for adequate consideration, and kind of have an idea into the mens rea of that third party. But I think this is kind of what I was alluding to.
Yes, because 126.2 says that a person is not guilty of an offense under subsection 1 if C, he acquired or used or had possession of the property for adequate consideration. So that would be a factor that would have to be taken into account where it may arise by way of a defense.
Right. Appreciate it. Thank you so much.
Yeah.
I have a question that may be linked to this, Judge.
Yes.
The fees that persons who are charged with anti-money laundering offenses pay to attorneys, can that be traced if they have been convicted of a money laundering offense? And have attorneys been targeted or subject to any prosecutions for money laundering?
The fees that have been paid to attorneys, your question is whether they could be?
If they can be traced. So you have a drug trafficker who has been charged and convicted with money laundering, and he's paid on a defense attorney money to represent him. Is it that he has to have legitimate sources of money to pay for his defense? Or can the prosecution then say all of his money was tied up in this enterprise and the money that has been paid to the attorney is subject to being traced and can be recovered as well, even if the attorney is not part of the enterprise?
If the attorney is not part of the enterprise, I would think that there would be difficulty in tracing the money. That would be my provisional response. I would have to look at it a bit deeper, but that would be my instinctive response.
Can I assist Justice of Appeal Mohammed? I think that the attorney would have given valuable consideration, and therefore he would have a defense to that. Actually, in the same way as in your tracing property example, when you referred us, I think, to section 63, if you go on to section 66, you'll see that there is an exemption to recoverable property where the property has been purchased for valuable consideration. So the running theme through the legislation is that when you're looking at the property itself, if it has been bought for valuable consideration by somebody who, without using the statutory words, but describing it, I hope, as we would all understand, had no grounds to suspect that they were themselves taking part in the receipt of tainted property, then the property is not traceable into the hands of that, and I'm going to call them innocent purchaser for value. So that the attorney who takes funds from a defendant who is charged with criminal activity might put himself at risk unless he has made a disclosure. Remember, he's taking on somebody who is charged, so there wouldn't be any issue about privilege. If there's no restraint order, he would surely want to protect himself, because otherwise there may be a risk that he has accepted criminal funds. So that there's a double head to this. It's, have you paid for it legitimately or given legitimate consideration, valuable consideration? And did you have any, in my phrase, any grounds to suspect that you were taking this property that was tainted? So I think that first of all, we're looking at two concepts, one in relation to civil recovery, and the other, of course, in relation to criminal prosecutions. You would assume, and in a criminal prosecution, you would expect there to be a restraint order. And once a restraint order is in place, of course, the attorney would be protected by being able to seek a variation to take out fees for representation. But absent a restraint order and representing somebody charged with money laundering and taking money from them might expose the attorney to risk. Under civil recovery, where a person buys property which is tainted without reason to know or suspect that that property is the proceeds of crime, and they give good value for it, they are protected and the property would be gone. And then you'd look to other means of recovering from the person who sold the tainted property. I hope that helps. I hope you agree.
Thank you for your intervention, Mr. Mitchell. As to the second part of the question, as to whether there were any proceedings against attorneys, in my jurisdiction, no, I'm not aware of any. I don't know if there have been in yours that you can speak to.
Well, as I had indicated earlier, one of the persons who was convicted, or the person who was convicted of money laundering in this jurisdiction was an attorney, but I couldn't find what was the offense that he was actually convicted of. If anybody, if Mr. Lucio, I don't know if you know what he was convicted of.
I do know that some of these are quite live and is under appeal. So
Oh, okay.
yeah.
Yeah.
could I go back to a question that had been asked by Mr. Lucio about the bona fide purchaser for value and the relationship between section 63 of FOCO and also 126.2, which Mr. Lucio mentioned. And I will ask both section 63, well, first section 63 to be put up on the screen. And 63.3. I just wanted to make a point here, which arose out of Mr. Lucio's intervention. Subsection 3 says that if a person disposes of recoverable property, which represents the original property, the property may be followed into the hands of the person who obtains it, and it continues to represent the original property. And you recall my answer had been that I thought that that was broad enough to encompass the bona fide purchaser for value. And then we encountered 126.2 that says a person, wait until it's put up. Right? 126 subsection 2, a person is not guilty of an offense under subsection 1. And we go to C. If he acquired or used or had possession of the property for adequate consideration. I just want you to bear in mind it doesn't stop there. There is a second prerequisite. It says, and without knowing or suspecting that the property was criminal property. So two things have to be established, that he acquired it for adequate consideration and that such acquisition was without knowledge or suspicion that the property was criminal property. So that's an important qualifier as well. I don't know if that helped answer your question a bit further, Mr. Lucy. That's
yes, Judge. Yes, I accept that totally. Thank you very much.
Right. Yes. And thank you, Mr. Mitchell, for your intervention as well. Yes, I agree in principle with what you have said.
Thank you, Mr. Mitchell. So my question is, how, as attorneys, are we not suspecting that the proceeds are from a criminal enterprise if the person has been charged with a criminal enterprise? Is it that you have extra due diligence you need to do to kind of pull yourself out of that net or web?
Right. Perhaps I could invite Mr. Lucio to indicate insofar as he's able to, in terms of what procedural requirements would be required of attorneys in particular in Turks and Caicos.
Oh, in Turks and Caicos, I'm not sure I could speak to that, but I did, just before you came back in, want to kind of put the attorneys' fears at rest, because even if there is a restraint order, there are provisions to allow for attorney fees and for other upkeep and maintenance of the person. And that goes beyond money laundering charges. There are persons that are sanctioned under Russian orders, Russians that are available, that participate in Russia's full-scale invasion of Ukraine, and they are subject to freezes, their accounts. But even them, they are allowed a provision to pay lawyer fees and to maintain their homes and their households and pay for their children's education out of monies that are seized. So I do believe that even though the investigation, they could trace that the person made wire transfers or made payments to their attorneys, the attorneys will not be subject in that instance to any kind of prosecution, because a person is allowed a right to defend themselves and to pay for their lawyer fees. So that's carved out within many Proceeds of Crime Act. Yeah. I hope that helps. Thank you very much.
Thank you, Mr.
Thank you.
Could the gentleman who asked the question develop it a little more in terms of the concern, the underlying concern?
Hi, Judge. It's me. You've addressed my concern. So there was just a query that I've had of how are attorneys exempt. So I know we have a right to an attorney, or persons have rights to an attorney. So I wondered if it was an intention to balance that right of a person to representation against this need to trace the proceeds. So I was wondering if attorneys are simply exempt because we are attorneys from the strict tracing requirements, and what due diligence we needed to do to protect ourselves from allegations that we are part of a criminal enterprise or that money has been deposited with an attorney that had not legitimate fees that can be subject to recovery?
Yes. As Justice Brown-Antoine said, I mean, one would, the best way to protect yourself is to ask as many questions as possible. So arm yourself with comprehensive knowledge. So you will know if there's a point in time where you have to disconnect. But the more information that you have to be able to make that judgment call and know whether you are in potential breach or you're susceptible to a potential prosecution or to some other action, the better for you.
Thank you very much.
Mr. Lucio.
Just a follow-up, Judge, to add that it's important that attorneys themselves do that same CDD and KYC when they are accepting clients, and do in fact ask the questions to understand the nature of the client's business and the nature of the relationship, so as to avoid they themselves being part, knowingly or unknowingly, of a money laundering scheme. And to also, in keeping with their obligation, with their duty under Section 127 of the Proceeds of Crime Ordinance, to report suspicious activity that is not within legal privilege to the FIA. Thank you.
Thank you. I can't speak to this, but is there anyone on the platform who can speak as to what attempts have been made to sensitize the attorneys and the takes and takers as to their AML responsibilities and their due diligence responsibilities? Or do you think there is a need for it coming out of this sensitization? Yes, Mr. Lucy.
Sorry for taking the floor again, but this sort of falls into my day-to-day job. So the FIA here, the Financial Intelligence Agency, that is the FIU for Turks and Caicos Islands, they are the ones that receive suspicious activity reports from all financial businesses, including attorneys and accountants and so on. So they do go out and have meetings with the attorneys, with the compliance officers or the money laundering reporting officers to sensitize them as to their obligations under the Proceeds of Crime Act to report suspicious activity. They provide them with indicators of suspicious activity. We do case studies, just as the one done this afternoon, to help them get an idea as to what suspicion looks like, the fact that there's not evidence, that the threshold is lower, and the use of the SAR form, how to fill out the form, what information goes in there to have a complete form, and the Financial Services Commission, just as with the banks, they are responsible for doing on-site inspection and supervision of the attorneys. So they have held meeting with the Bar Association to reach out to their members to sensitize and have these same sort of forums and engagements back and forth. The last thing that they do here is they have a public-private partnership forum where the regulators and private sector, including the Bar Association and attorneys, would meet to discuss the legislation, any amendments that are required, any updates that are coming, so that they are aware and they can work together to support the public sector, because the private sector are the ones that are on the front line implementing these obligations. So those are some of the ways that they sensitize the attorneys.
Yes, thank you for that, Mr. Lucio. That seems to be an impressive amount and quality of sensitization as well. Anyone else? Justice Brown-Antoine, was there any aspect of the questions asked that you wish to weigh in on that impacted on money laundering?
No, I think it was covered by all the interventions. I think dealt with the issue of the exposure of attorneys and sensitization, and also disclosure and so on, attorneys balancing their legal professional privilege as opposed to ensuring that they're not participating in money laundering in money laundering schemes or such. So I think it's all been covered, and I think yes, those answers would provide guidance to anyone who has those issues. So no, I don't think we need to. Yeah, that was sufficient for me.
Thank you. Mr. Lucio.
Well, I do have more to say if there is a few more moments for me to share. So it was said earlier that there are certain risks that we face here in TCI on account of how our economy is built on the provision of offshore banking and international financial services. And the fact that we are a company formation center, right? A lot of foreign companies are created here by persons that are overseas, and those companies are operating overseas. So those are some of the risks that we are aware of. And I know this morning was spoken of as well, the fact that we are along a known drug trafficking route. And because of the nature of the islands, it is very difficult to secure the borders entirely. And therefore, we are vulnerable to drug trafficking and the cross-border movement of bulk cash as well. So to better understand those risks, here in TCI, we are engaging in a national risk assessment process where we are looking at all of the potential illicit finance that can be obtained from a list of about 23 or 24 offenses, including drug trafficking, human trafficking, migrant smuggling, and so on. Given our geography and our close proximity to an island that is pretty much a failed state, and the risks that is posed to human trafficking and migrant smuggling, we are assessing that as part of the risk assessment as well. We are assessing the vulnerabilities, and one vulnerability that comes up repeatedly is real estate and lawyers. The legal professions are part of real estate transactions, and the high value of real estate here in TCI means that it is easy to launder $500 million in one transaction. Lawyers play a very critical role as a gatekeeper in that sector. And some lawyers also have a license to create companies as well. So they are also involved in the creation of foreign companies. And oftentimes, as we've seen with the Panama Papers or the Paradise Papers, companies are involved in money laundering schemes. So those areas present elevated risk of attorneys. And added to that, we do have the experiences of investigations and prosecution of attorneys for money laundering offenses. So that is an area that is particularly high risk. Even though we've not completed the risk assessment yet, all of the preliminary information indicates high risk. The challenge is that we don't often see here money laundering investigations consistent with the risk to the jurisdiction. So while there may be a risk for drug trafficking, given our geography, and we have several examples of large volumes of seizures. Quite recently, we had a $2 million US dollar seizure and a $1 million seizure over the weekend as well of drugs. Quite often, we do not have money laundering investigations that follow. It might just be the drug seizure, and that international control delivery that we saw in Bahamas. Is it Bahamas? Bermuda. We don't often see those policing techniques being used to identify persons associated with the drug trafficking or with the human trafficking or migrant smuggling. So we do have a challenge with migrant smuggling, migrants mostly from Haiti, Dom Rep, and Jamaica to a lesser extent. But similarly, one would expect that if these are the crimes that bring in the profit, then there should be money laundering investigations consistent with that threat. And that is also something that we have been working on to ensure that there is a parallel financial investigation that accompanies the investigation into the drug trafficking or into the migrant smuggling. And I'm very happy that the JEI, Turks and Caicos, and the corresponding entity in Trinidad and Tobago have collaborated to do this training. This training is also required at a practical level, even more so than the case study, for all our law enforcement authorities, so they are aware that they can seize cash, that the circumstances of the 72 hours, of the 2 years, and maybe even utilizing what Mr. Mitchell said about going after a forfeiture. Because once those proceedings are instituted, the 2 years sort of ceases to limit, but that's a different story. So we are doing this NRA, and we are updating, Judge, our national strategy. I saw you quoted it. It's a 2021 to 2023. We are updating it now with a 2024 to 2026 period. And after our NRA is done, we will revamp it to include any other areas where there are gaps in the system. At the end of our NRA, we hope to have a risk-based allocation of resources. If we see drug trafficking is where the illicit finance is coming from, we need to have a proper drug trafficking unit, have them equipped, well outfitted to tackle that crime. If we see it's coming from real estate transactions, then the Real Estate Association, the real estate agents, the Financial Services Commission would need to take steps to ensure the real estate agents are applying CDD and KYC, and even sanction those that are found to have severe deficiencies that they are unwilling to mitigate. The last thing I would like to add is on the unexplained wealth orders. And I know you mentioned it sort of as a suggestion that we should consider it. I agree. And apparently the Financial Action Task Force, the FATF, the world governing body that oversees AML CFT, also agreed with you. And in just August 2024, published their new standards. And in their new standards, countries are required to have a non-conviction based confiscation, of which unexplained wealth orders is one type of that. So we would have to take your consideration on board and have some legislative provisions to ensure that we can do that, and the subsequent training of our LEAs to ensure that they are aware and that they can, and we can demonstrate that we can do unexplained wealth orders or non-conviction based confiscation. So thank you very much for the additional time.
Thank you, Mr. Lucio.
Thank you very much, Mr. Lucio.
You weren't going to escape my question, and neither Mr. Mitchell, Ms. Ferguson, or Mr. Emmanuel, and anyone else, as to what was your perspective on the recommendation for the implementation of an unexplained wealth system. So it is less a recommendation coming from me. That's something that is coming from the Financial Action Task Force and the Caribbean Action Financial Task Force, which could see your islands being grey listed, or even in a worst case scenario, given your particular vulnerabilities, blacklisted, as Trinidad and Tobago was at a certain point in time, blacklisted and then put onto a grey list, and we are still in a somewhat intermediate position unless certain things are done. So if the implementation of a non-conviction based system, which would be the unexplained wealth system, is now a positive recommendation, and you stand the risk of being grey listed or downgraded because of that, it's something that you will really have no choice but to consider. With respect to the law enforcement agencies, police, customs, the prosecutors department as well too, the AG's office, prosecutors, real estate agents. I hear you saying as well, Mr. Lucio, that there may very well be, or there is a need for consistent, ongoing training of law enforcement agencies, prosecutors, and if it is established that there's a particular vulnerability in the real estate industry, and you seem to suggest as much very cogently, that then there needs to be special efforts dedicated at that. Do I hear you correctly?
Yes, yes, precisely, Judge.
Mr. Mitchell, would you concur as a senior practitioner in the jurisdiction? Would you concur with those sentiments?
Yes, yes, I do. Thank you for asking me. I do very much.
Yeah. So it seems then that everyone seems to be on the same page as to where Turks and Caicos has to go. Well, it's not a case of preference. It's a case that if you are to maintain your financial viability, and if you are supposed to maintain your reputation for financial integrity, then these things have to be forthcoming. There's little choice left to be done.
I'm not sure if we're all on the same page with that, especially in relation to the unexplained issue. Because it appears to me that there could be what one could interpret a reverse burden being imposed on certain individuals in that particular situation. And I'm not sure how you view that in relation to what the Constitution requires in terms of the presumption of innocence and the fact that the burden remains on the prosecution.
Can I comment? Oliver, welcome. Firstly, of course, they're civil proceedings, not criminal proceedings. And secondly, the principle of unexplained wealth orders has been upheld as a small c constitutional right and in favor of the state in many countries. So that whilst I appreciate the concerns, an unexplained wealth order is nothing proximate to a criminal conviction. So the right against self-incrimination or reverse burdens are not relevant. And secondly, it's a constitutionally sound, recognized Jamaica, Trinidad, UK, European Union way of recovering proceeds of crime.
Casey, Mr. Smith, the constitutional validity of unexplained wealth orders has been approved of in Trinidad and Tobago. But that's an area that may be open for discussion in your jurisdiction. So I wouldn't want to venture there.
Yeah,
and
that's the point I was making. I do recognize that there are some jurisdictions that have sanctioned it. Jamaica being one of them, and Jamaica is what I'm familiar with, but that it still remains an open question here.
I see. Yes. Thank you, Mr. Smith.
Just to add, Judge, on the question of training, I'll just indicate that this year the judiciary has held a training on the procedure of crime. And I'm aware that the Office of the DPP has also conducted training on proceeds of crime or anti-money laundering. So just to add that there are trainings that have been conducted, and I'm glad to hear that a lot more in the works.
Thank you, Mr. Seaman.
Are there any training for the defense bar coming on stream in relation to those?
I can't speak on behalf of the JI yet, but now that I know it's a topic of interest, it's something that we can look into, Mr. Smith-Casey.
Thank you.
Thank you.
Mr. Smith, Mr. Mitchell, could I intervene by asking that do you think that there's a need for greater sensitization of the defense bar, of the private bar?
Absolutely.
Definitely, yes.
Absolutely. I'm and indeed, Oliver, I'm very happy to suggest you and I do something together, because that will give everybody a reflective perspective.
I welcome the offer.
Yes, so both Mr. Smith and Mr. Mitchell, you're both of the view that more training should be directed towards the private bar.
Yeah, because there's actually been no training in relation to that as far as the private bar is concerned. It's more to the law enforcement side of the jurisdiction.
Yes.
Good afternoon. The JEI undertakes to do training as requested by the bar.
Thank you, Chief Justice.
You're welcome.
Very grateful, my lady.
Thank you, Honorable Chief Justice.
You're welcome.
Mr. Smith, may I ask if the specific training is concerning non-conviction based confiscation, is he training about unexplained wealth orders that you're seeking to have?
I think the entire bar needs to start from money laundering 101.
Okay, understood. Thank you.
Thank you, Mr. Smith.
I think we have time for just one more question. Before we move on to the vote of thanks, is there anything you would like to say, Justice Mohammed, or you, Justice Carla Brown-Antoine?
Justice Brown-Antoine, I'll pass over to you first, and then I'll come up.
Yes, all right, thank you. Well, once again, I would like to say thank you for having us. Thank you for the privilege of interacting with you on this subject. I've learned as well from you, and so it's not that we're here to impart knowledge. We are also here to learn. So I've learned as well. I've done a few of these anti-money laundering workshops in other jurisdictions, and so we've learned a lot about your in fact, in preparing for this this workshop, I learned a lot more about Turks and Caicos than I've known for a long time. So it's a learning experience for us as well. So thank you for the opportunity to interact with you, and hopefully we will see some of you at Cajo soon. And thank you for the and just let me say on unexplained wealth orders, respect to Trinidad and Tobago. You have before you the first judge to issue an unexplained wealth order in Trinidad and Tobago, and the first justice of appeal, Justice Mohammed, to sit on to review my decision in that matter. Yes, Justice Mohammed, I turn back to you.
Yes, thank you, Justice Brown-Antoine. I would like to endorse your comments, Honorable Chief Justice and President York Suhan of the Court of Appeal and members of the JEI. We would like to thank you very much for inviting us to participate in what, in our experience, in my experience, has proven to be a very interactive session and a very thought-provoking session. What has impressed me the most is the frank dialogue that has taken place, especially this afternoon, on the need for further training on certain areas, and the position of the defense bar that there is a crying need for ongoing training, and the commitment of Madam Chief Justice to provide that training. That struck me as a move in entirely the correct direction. Is the way to go. So I think that all parties are on board, are on deck to accomplish the same objective, and I commend you for it. And we thank you once again for inviting us.
Thank you very much, Justice Mohammed. I'd now like to invite Ms. Tanya Carter, the Executive Director of the Office of the Chief Justice, to give a formal vote of thanks. Ms. Carter.
Yes, please. Thank you, Mr. Emmanuel. Good afternoon, everyone. To Justice of Appeal, Mark Mohammed, and Justice of Appeal, Carla Brown-Antoine, on behalf of the judiciary of the Turks and Caicos Islands and the JEI, we wish to express our gratitude to you both for the insightful and informative presentation on anti-money laundering, which took place over this entire day. The fact that the topic itself needed a full day shows how diverse and interactive it can be. The contents of your presentations were well organized and provided a comprehensive understanding of the significance of combating financial crime. The real-life examples that you shared and also the particular references to Turks and Caicos Islands during the presentations were particularly valuable, and you have both provided us with a deeper understanding of this crucial topic. I wish to also express gratitude to Mr. Lala, the Judicial Research Counsel assigned to Justice of Appeal Mark Mohammed, for your assistance throughout today. And in closing, again, I would just like to say thank you both for taking your time, which we know is very valuable, to share your knowledge and experience on this topic with us today. Thank you once again, and I now hand you back over to Mr. Emmanuel to close off today's session.
Thank you very much, Ms. Carter. And that brings today's presentation to a close. So on behalf of the JAI, thank you very much, everyone, for attending day 2. You'll notice in the chat that we have placed some feedback surveys or links to feedback surveys from today's presentation and from yesterday's presentation. We'd be very grateful if you can complete those. And we look forward to everyone's attendance tomorrow at day 3, where we will tackle justice for vulnerable persons, as well as issues in social media and the judiciary. So thank you very much, and thank you for attending JAI Week. Good afternoon, everyone.
Good afternoon.